Honourable the President.
Welcome back, everyone. So we are going to proceed. I believe we're on clause 34.
Clause 34.
The question is that clause 34 stand part of the bill.
Madam Chair, the government has circulated amendments to clause 34, which comprises amendments to clause 79I, clause 79J, and if I may explain those to honourable senators.
All right, before you do that, Honourable Attorney General, I suspect that members may prefer if I go through 79A.
Sure.
In case there are any issues that members would like to raise before we deal with the items that are under amendment, okay? So, (79A). (79B). (79C). 79D.
Through the chair, Madam Chairman, my concern with respect to 79D, in which I had a look at the particular section, it deals with an offense being committed when a vehicle breaks a red light. And there's a citation that would be sent wherein the owner of the vehicle would be held responsible for that breach. My issue is that and then subsequent to that, the owner then can recover the fixed sum from the individual who may have been driving the vehicle if that person is not the owner. But that would then place, how is one to enforce such a situation? If I lend my vehicle to my daughter, or it is left at the mechanic, and the mechanic is the one who takes the vehicle and he breaks the red light, I am the one who has to pay this penalty. How am I then to enforce this particular section?
Sure.
I would have to take this individual to the court. That's the question.
Honourable Attorney General.
Yes, Madam Chair. Good points raised because it goes into the operation. So this clause itself doesn't deal with that. So it's just the deeming of the owner, but the Honourable Senator is quite correct. The latter clause where you have to find the mechanism to indemnify yourself, which the bill provides, does require you to knock on the door of the person who has actually committed the transgression, and if they don't agree, that you then enforce by way of action. I just remind that this particular system is the exact system which exists in every country around the world where, for instance, in the United States, where they have what they call SunPass mechanisms, where you have a rental, you enter into a contract for a rental, you break the signal or you don't pay the toll, it automatically is uploaded. The company that you rented from pays the bill, but they promptly send you the bill and debit your credit card. So the system is going to work itself out such that in arrangements like rental or fleet vehicles or ministry, that automatic indemnity would kick in by mechanisms. But the Honourable Senator is correct. you would be forced to indemnify yourself by action yourself if you needed to get there.
Honorable Attorney General, the only issue is, as I gave the example of leaving the vehicle at the mechanic, and he is the one who breaches the red light or whatever the case is. Because I'm fully aware with respect to the SunPass situation, they debit the credit card. But for a single mother of 3 children, how is she then going to enforce this against the mechanic? She would be the one who now has to go to the court because there's no indemnity involved in that particular situation, and that now places persons back at the court's door.
Yeah.
And petty civil is something that is very, very
Tedious.
tedious, yes.
Yeah. Senator, you're perfectly correct, but may I remind that there's Privy Council dicta in the presidential insurance case that prohibits you from even lending your car to an unauthorized driver. So the jeopardy exists in multiple realms of the law. If your mechanic was driving your car and was not listed on the insurance policy for third-party insurance purposes as an authorized driver and had an accident, you have no right to reclaim under Privy Council dicta right now. So there are many examples where there would not be coverage and that you'd have to take indemnity action yourself.
Madam Chair, in light of clause 79D, my apologies.
79, sorry.
79D.
Yes.
Yes. In relation to the red light camera captures of photographic image or video recording, and this is for the indication of a red light of a traffic light signal conviction. I would like to know if it is the intent of the administration to use these photographic images or video recording to for offenses of criminal offenses.
They
And
do.
I can give an example.
Sure.
For example, recently in our country, there have been persons who are approaching persons at the red lights in our country where they are trying to wash your windscreen, and their intent is to lower your glass so they can then try to rob you or take your vehicle. Even if you don't pay them, they are aggressive and they dash water into your thing. So this is an example that's happening right now, and I want to know and they are said to not be Trinidadians too, so I want to know if this provision in this bill would be to address that issue.
Whilst it's squarely outside the provision of this particular law, it is a very good point raised by the Honourable Senator, and the answer is any evidence which can be sustained in a court of law as meeting the characteristics of admissibility can be used in a court of law. So the answer is potentially yes. It would have to satisfy the conditions for admissibility in court, and there are certain standards and mechanisms that you go through. I should tell you that we are looking at how one treats with CCTV footage from an admissibility purpose, and that's a work product inside of both the Law Reform Commission and the LRC, which I'm trying to tighten up now. It's been a product in discussion for a very long time, but it hasn't taken full leap ahead. So we're looking at it.
Senator Richard.
Thank you, Madam Chair. Through you. Following from that question, Mr. Attorney General, does that mean that we can glean from this that these images and video footage is specifically for the purpose of traffic offences or violations,
The answer
as it
is
stands?
within the purposes of this bill, yes, but related to what Senator Ramkisoon raised, there's nothing to stop someone calling in aid for the commission of another offence, this kind of evidence, to be circumstantial or corroborative of something else. You can subpoena those records in other proceedings and find utilization there. But there may be objections, and that's where the whole rules of evidence come in as to admissibility, etc., etc.
79E. (79F), (79G), (79H). Senator Shriki Soon.
Madam Chair, through
79 each. Yeah?
with
Senator
respect to
Srinivasan?
Sorry, Madam
thank you,
Chair.
ma'am.
I'm so sorry, Honourable Senator, to interrupt. I was just receiving some information from our technocratic team in relation. Do I have your permission to just refer back to 79G? Should it please you, Madam Chair?
Yes.
Seven-
79G?
79G, Madam Chair, we have need to just change the reference from minister, the definition of citation notice. We would need to change minister to authority. And it wouldn't be a prescription by the minister, it'll be approved by the minister, by the authority. So in 79G,
Where?
79G.
Se-
G.
right. So in 79G, because we have referred to the licensing authority, the incongruity is in 79A, where the definition appears. So with your permission to come back to that, if that's possible, Madam Chair, in 79A, which is on page 11, we will see
Which definition are we dealing with?
citation notice, Madam Chair, which is on page 10. Citation notice means the notice, we're proposing that instead of the word prescribed, it'll be approved, and that it would be, instead of the word minister, it would be the word authority. And that's to be in congruity with 79G. Thank you, Madam Chair. Apologies, you were on H and Senator Srinivasan had the floor.
Madam Chair, to you, Honourable AG. My question, as I raised before during the debate, was that the legislation here with respect to the citation notice doesn't really specify who has the responsibility to serve the citation notice, which agency, whether it's the police, whether it's the licensing authority. And I think I'm just seeing that as being absent here, or I'm probably, through your guidance, correct me.
Honourable Senator, the rationale for drafting this way is built upon the following. The obligation in law, the strict obligation, the person who shall cause the thing, and I'm using cause in a specific way, will be the police. The officer with that authority who has observed the event and who confirms after review that the signal was working, it was properly maintained, there were no irregularities, the traffic lights were functioning, the photographic image demonstrates that there was a coincidence between event and violation. That person would have the obligation to cause in law the issuance of the notice. That methodology we are going to implement via TT Post or other mechanisms. So we're going to use method of transmission, which is not dealt with in law, specifically to allow us to improve as we go along. As we bring the database live and we have real-time information and coordination between drivers, owners, and the authority which regulates them and holds their data, we're going to use multiple methods. Email, post, if we can't get them, service in the newspapers, etc. So who causes? The officer. How it is done? Specifically left fluid to deal with the evolving capabilities of technology and transmission.
I'm just a little bit confused, right? Because you're telling me that it's the police officer who oversees the violation, that it's now the responsibility. But 79G refers to or 79G refers to an inspection officer, And according to the definitions of A, inspection officer means a constable, transport officer, or traffic warden certified by the Commissioner of Police.
Yes.
So I'm saying multiple agencies involved.
So the person who will be designated for this function in the rubric of availabilities, constable, officer, etc., all of whom have certain powers at law, once public officers or officers who have the backing of a service commission, who have certain powers prescribed under authority of law to them, Police Service Commission, Public Services Commission, etc., all of these entities allow for various officers along the way to be involved in the process. So whomever that person shall be from time to time, be it a constable, be it a licensing officer, etc., that is the person who will issue in arrears. Because what happens is you pass through the traffic light, you have the flash go on, they get your number plate at the back, they get your lane, make description, it's referenced back to the licensing office, the last known registered owner pops up, all of that information, together with the prescriptions in 79G as to what ought to happen, get put down in arrears. It's not simultaneous. There's nobody standing to give it to you instantly like with the speed enforcement cameras. That goes in arrears, they check it, which is why there's a time lag prescribed in the legislation, and then it is issued to the person by post or other means, etc.
Right, I'm just trying to identify how is it that an offender is supposed to be deemed adequately or appropriately served?
Which is why we have multiple measures.
Right, but that's via the medium.
Medium and including
But which
service.
is the agency responsible? Is it one, is it multiple?
Pardon? Would you just say that again?
Is it one agency responsible for serving the notice? Is it the police? Is it the licensing authority? Is it? That is what I'm trying to...
It's in the category that you just read, the constable, the inspector, the etc. So that there are multiple persons who have the capability to do it and who would be caused to do it. In the one example that I gave, it was the police example, but it's within the definitions clause. But it's within the rubric of the law of the clause as constructed.
So they're responsible for both service preparation and the service?
Yes, sir.
Okay.
In Jamaica, for instance, how this is done, they share the responsibilities, and in fact, they outsourced it. So they actually hired contractors to do it. We specifically didn't take that route. We wanted to keep it within the rubric of the statutory entities that had the lawful authority to do these things so that they could be disciplined by Public Service Commission, by Police Service Commission, etc. There must have been a proportionality for somebody who did it wickedly, and contractors didn't fall within that approach. You could have sued them, but you couldn't compel them to suffer a penalty the way a Service Commission could.
Thank you.
Senator Mahabir.
Thank you very much, Madam Chair. Taking off from my colleague Senator Shriki Soon on 79H, the service of the citation, notice Honorable Attorney General. 79HA indicates that this notice should be delivered to each owner or some adult member of his family, and I would like to know what really, in this context, the definition of a family member is. Does it include parents? Will it be served to my 90-year-old father, for example, 87-year-old mother? Or is it that you have a different definition of family? So I'd like to know which family member under law is entitled to receive this notice on my behalf.
And if you
but what I
just...
also have an issue with is, with respect to the last few words, it is going to be delivered at his usual or last known place of residence or any address furnished by him to the licensing authority. So that if it is that an address has been furnished by our offending driver by the licensing authority is his last known place of address, he does not live here anymore. He rents, but he of course leaves that place. A notice comes to his tenancy. A new tenant says, well, this person doesn't live here anymore. He now lives at residence X, Y, or Z. Does the fact that his address, new address, has been given not by the licensing authority, but by a tenant who is now occupying his former place of abode, negate the fact that his address in law was not furnished by the licensing authority, but by some third party. So family member and his address given to the server of the
vagaries of that.
citation
Understood.
by someone other than the licensing authority.
Could I invite Senator Richards, as he had a coincidental
Thank
point?
you.
Please, Madam Chair. Apologies. Didn't
Thank
mean
you,
to
Madam
usurp
Chair.
your function,
Thank
Madam
you,
Chair.
AG. Because it's related, and running from Senator Mahabir's point, where does the responsibility lie in terms of the serving agent to verify that that person has indeed received, given the fact that, yes, an adult member of his family, that specified adult member, presuming someone over the legal age, and that person will indeed deliver the message to the individual as intended by the serving agency,
Sure.
Because of the liability involved here.
Honorable Senators, through you, Madam Chair, you've hit the nail on the head. It's an important core concept of how we operationalize a novel approach in the law. Permit me to say that the answer involves an appreciation of the bill as a whole. With respect to the meaning of his family, let me deal with that one first. Family is going to be interpreted within the literal or purposive, let's stick with the literal meaning of interpretation. So one of the methods for interpretation of statutes is going to be the literal or ordinary meaning of the words, and therefore family falls into that context. It's true, in Trinidad and Tobago, the concept of family may be large. Anybody who is greeted with the expression family, in a long sense, knows what we all mean. So there may be some difficulties in pinpointing the accuracy of consanguinity versus living in the same house as common law, etc. But what will happen is that it will be ultimately determined when one comes to object that one is now the pointed target of a violation, that this is something which is running afoul of the logics of what a family means. Secondly, it's open in any event for us to consider that the mechanisms flow through a process, and that if you object, if you're caught in this net and you object, the bill provides for a process by which you can get down to the line and say, look, I object for the following reasons. I don't live there. I moved a long time ago. Here is the letter where I informed the licensing authority that I moved. They got it wrong. Then you're going to come down to the point of the photographic evidence saying, well, is this your car or not? So proving that you weren't served versus whether it was your car or not collides with logic. The next position is...
Reggie, if I could just interrupt so you could just clarify
Sure.
through you, Madam Chair. Doesn't this then leave a gaping loophole for someone who wants to escape their liability by just saying, one, that was not my family, two, the person may have been given this document, but they did not give it to me, given the construction of this?
I'd respectfully respond by saying no, because that's your method of service. The question is still, is it your car? You, the owner of the car, are being invited to be liable for offenses or now violations committed by your car. The bill provides a defense, which we're actually going to propose is to be amended in terms that I'll come to in a little while, which says that you have defenses if you're not of the car, if your car has been stolen. But you still are going to have to address the point, well, okay, so the service was wrong, but is it your car? But just before Senator Choate jumps in, through you, Madam Chair, if I could just finish the responses to the other two limbs. So there's a process to get there by way of objection as to whether you are the correct person to be liable for this violation. Are you the registered owner of the car or not? The law provides, Chapter 4850, a positive obligation upon persons to give their address. The description of or any address furnished by him to the licensing authority is meant to capture that continuing obligation which is often not practiced by members of the public, to update their records. It is the same thing in relation to the land laws of Trinidad and Tobago, where you're obliged to actually update your residential information on a continuous basis. And both are done in the spirit of anti-fraud, so that you can actually know that this person is the person associated with that address and not somebody by the same name from a different address. And that is the rationale behind it. So, meaning of family is a concept to be given literal interpretation. Meaning of any address furnished by him to the licensing authority is, again, to deal with the fact that you may have had a registered address for a corporation, for instance. You may have had a residential address. You may have updated your information. And there's a continuing positive obligation in the other parts of the law not amended for you to update your information. Proof of service was the point that Senator Richards raised. Who is going to prove that the service was right? One of the main mischief points that we sought to address by treating with violations as opposed to offenses was that in offenses under the Summary Courts Act, you had to issue a summons or a warrant. You had to go and serve it upon the person. You had to return a proof of service to prove that the person was there. And then, in Section 44 of the Summary Courts Act, once you had service dealt with, you could have proceeded in absentia or ex parte. Senator Ramlin had some difficulties remembering that particular point, that it's existing law on that point. What we're doing now is we are reversing the position. We're saying no longer will we come looking for you. If you want to contest, you issue your own summons by providing a notice to contest. And you having issued your own summons, that's proof that you're involved, and therefore you can proceed in absentia. I'm just showing you the logic. So this proof of service is now proposed to be treated with in the context of 79H by going through the steps by which you can serve a document. At the home, at the last known address, by registered post, by hand delivery, or by publication in the newspapers. But bear in mind, if all of that fails and you find yourself now subjected to the imposition of this violation or penalty, etc., the ultimate sanction is going to come down either in a court of law or at the licensing authority, where your transactions may be suspended, etc. And at that point, you also have the ability to say, I object to this being imposed, and I'm showing cause why for the following reasons. It wasn't my family, I didn't live there, I didn't know about it, I actually am no longer the owner, it was transferred to John Brown. So there's a whole matrix applied to try and catch this situation, and we borrowed from a number of jurisdictions which have similar experience. Jamaica, the United Kingdom, the United States of America, and New Zealand.
Senator Choate, you wanted to raise an issue?
Yes, thank you, Madam Chairman. I was going to suggest, Honorable Attorney General, that perhaps consideration could be given to taking out the words member of his family entirely and simply using by delivering it to each owner or any adult at his usual or last known place of residence. That might make it easier in terms of
Yes.
being able to serve the document.
I have no objections. I think
Yes.
it's prudent.
Thank you.
So we will be taking off you're proposing that the word member.
Indeed, so I beg your pardon.
Yeah.
I do so propose.
All right. 79I, Honorable Attorney General, I think this is where you have
Yes,
an
ma'am.
amendment
Thank you.
circulated.
79I, which is on page 15 of the bill, proposes to correct an inadvertent mistake. We cross-referenced the wrong clause. So we're proposing that we delete 88C and substitute with 88D. We're also proposing that, yes, that's it for 79I to B. There's another one to 79J when we come to
Just
that.
one sec, yes. So 88D. Honorable Senators? Okay, 79.
Just want to ask, earlier, you had indicated that You wanted to change minister to authority, right?
Yes,
In the definition.
79E.
Would that apply to this particular clause? The B? B of number 2 says
I'm gonna
paid
double
to a
check.
payee
No.
prescribed by the minister under 88C. So I'm just asking, seeing as we
Sure.
we changed, made the change in the definitions, would that apply here?
I've just double checked. I'm advised that this one stands as is, because here's where the minister would give the prescribed list of payees, FCB, some other bank, TT Post, or on those ends, or the court. Pardon? 88C changes to 88D.
It changes to D.
All right, 79J. Attorney General, you have,
Yes, please, Madam Chair.
yeah?
Again, at subclause 1, 79J1, it is to change 88C to 88D. Secondly, we propose that we take cognizance of the submissions in the Senate by members opposite on independent and opposition bench, that there was a loophole in the subclause 2. In particular, we consider that there could have been a position where you were no longer the owner, but it was in dispute. You had not had a transaction completed, etc. So we're proposing now that the defense is, 1, your vehicle was stolen, 2, that you're no longer the owner, having duly registered a change of possession of the motor vehicle in accordance with 19.1. So that was to tighten it up, to make sure that it was only after the event was concluded at the registry that you would then have the availability of this particular defense.
Madam Chair.
Senator Shrikisu.
To the Honorable AG, I raised an issue with respect to this clause concerning that the vehicle identified in the photographic image was not the vehicle owned by someone who had a vehicle sharing the same registration plate. So at that point in time, it would just be he was not the owner of the vehicle in the
False plate.
in the
Yeah.
photographic image. How would that be included as a grounds that he was just not the owner, full stop, because he could justifiably show that he was not the owner?
So it would involve somebody saying, look, I've been advertised. Let's say someone got a notice, or they were advertised. It was somebody with a fake plate using your same point. The immediacy of a defense would present itself because there's a photographic image. It was PDB 55, which is attached to a Nissan Sentra, and in fact, your PDB 55 was a Nissan Tida or a Range Rover or a truck. And automatically the image says, well, there's something wrong inside of there. That's why the photographic evidence goes along with the position. Does it take care of the fact that there would be falsity in plates? Not now. However, with the introduction of the RFID plates by regulation, which we are going to complete this year, we will have randomly generated plates, which should be taking care of the issue of duplication of plates, because numbers are going to be dealt with in a totally different matrix.
Chair.
Senator Samuel.
I was privy to, just to make a point, similar situation, but the vehicle that they put the false numbers on was the same color and make of the vehicle that they stole it from. And in a situation like that, they break the traffic light, the camera snaps it, it's the same vehicle,
it can happen.
Same model, but it's not you.
It can happen. It is also referred to your chassis number and engine number. So your chassis number and the coincidence can be drilled down further into make material, because when it comes up and it says Roger Samuel, forgive me for just giving an example, right? Roger Samuel, X number plate, on the thing, on the notice that comes to use your chassis number and engine number. When you come up to the position and you show that point, I know that there's a difficulty because you can't see the chassis number and engine number in the photograph. But incidences of fraud can happen. It happens in land registration, it happens in deeds, it happens in a number of arenas. Are we going to have an entirely foolproof mechanism? No. It may be for you to produce circumstantial evidence that you were not there, so you have witnesses to prove you were not there. I can't speak to it.
Senator Mean, you wanted to read something?
I appreciate that the Attorney General took into consideration the contributions made during the debate and added on one more condition that could be used as a defense. But clearly, as you are indicating even now, the circumstances surrounding every violation could be very different. Can we really legislate possible excuses or possible defenses? We can't, because we can imagine several scenarios and keep coming up with more additions here. And during the debate as well, the point was raised as to limiting an offender's defense. Should it be that they would have to prove to the court, and of course the magistrate makes the decision. But this still, even though you have added the clause with regards to where a vehicle is stolen and so on, it still limits the defenses that you can put. If my excuse or my circumstances are different than the three things prescribed here, then I am without a defense. And it limits me in terms of what my defense could be, even though my situation could genuinely be different. And I think that we should not be telling the court what qualifies as a defense.
Attorney General.
Sure. Well, there's nothing in law wrong with telling a court what your defense can be, where you don't even provide a defense in strict liability circumstances. So it's not an unusual feature of the law to do as we have. In deeming an owner responsible for a traffic violation, it's either you're the owner or not, or you were relieved of the ownership temporarily because somebody took control of your property when you didn't know. Was the issue of fraud? Can we legislate perfectly for fraud? No. In any field of the law, in intellectual property, in mortgages, in conveyances, there will always be the opportunity. In passports, there will always be the opportunity for fraud.
Senator Shriki Soon.
Madam Chair, Honorable AG, if we just consider he was, according to the clause, he was not the owner of the motor vehicle, full stop, and allow the person to justify the reason why.
That's what we had at first. So the existing clause is he was not the owner of the motor vehicle at the time the traffic violation was committed.
Right.
Senators opposite found fault with that. So we qualified it to say he was not the owner having duly registered the change of possession, because there's a gap between equitable and legal ownership in transferring ownership. I've bought your car, I've paid you by certified check.
It's not transfer.
I've gotten a receipt, you have possession, you are in equity the owner. In law, until the registration is changed, I'm the legal owner. So you're cleaving ownership into equity and law. And therefore what this does is remove the uncertainty of the gap between equity and law by providing for it to be a coincidence of equity and law. So we tidied it up from that perspective.
And I'm just asking, if we just say that he was not the owner of the vehicle, full stop, would it not
Which
cover-
ownership though? That's why I painted out equity and law.
Right.
Because there are two types of ownership, and in common law, equity trumps law.
Sure. Understood.
So, Honorable Senators, 79K.
I can't support that, Chairman.
Okay. Senator Mark.
Yeah, Madam. Yeah, Madam Chair. Yeah, Madam.
We've moved on, Senator Mean. We are on K now.
Oh, yeah.
We're on 79K. We've had extensive discussions on 79J, and I've been looking up and looking. Anyone who wants to catch my eye.
Oh, so we're going from J.
We have gone from J. Yeah? So we're now on 79K. And I am looking to see if anyone wishes to catch my eye. Senator Mean?
Senator, sorry, 79J went to a vote already. We didn't put it to a vote yet. That's why I thought we were still on it. It didn't go to a vote.
We haven't gone to vote.
Oh.
Clause is clause 34.
All right, honorable senators. Honorable senators,
My apologies, I understand, Madam
but let me,
Chairman, no
hold
problem.
on one second, Attorney General. Let me just remind you what we are doing. We are doing clause 34, and because I appreciate that members will want to ask about the different parts of clause 34, we are dealing with it. Where amendments have been proposed, we have taken the amendments on board. At the end, when we reach the very end, I will then put the question to the vote on clause 34.
Thank you, I appreciate
Okay?
that, yes.
So, Attorney General,
Honorable Senators, if we look at the proposed amendment that we're offering to 79G,
so Attorney General, you
Yes,
have
ma'am.
gone back to 79G?
well, the question was just put, Senator Amin said she can't agree to it, and I didn't hear a response.
Because we haven't put it to the vote.
Correct,
yet.
because it's Section 34 to be put to the vote, I understand.
Right, no, let me just clarify. I moved on.
Right.
Thinking that there was considerable discussion and dialogue on 79G. Is there something else you want to say?
Yes, thank you.
Sure.
Please, thank you. If we were to remove the word only from 79G2, so instead of an owner may only file a notice to contest on the grounds that at the time the traffic violation was committed, A and B, if we remove that word only, it could provide for some other circumstance to develop. And I think that that might meet with some of the discussion that we've just had. So unless there's an objection to that, I would, may I canvass the views through you, Madam Chair, on that proposal?
Before
the views are canvassed, what is the proposal to amend where? To amend 79J where? At 2? To delete only? Okay.
In the
AG
draft
to
as
provide a
circulated.
wider defense for an
Yes.
individual.
So-
Very well.
So it would not run afoul of a strict prohibition on any other form, like fraud or other aspects. It would allow for judicial. There were two approaches. You could leave it to the court to say, well, let's strike out the word only and read it as such, or we can leave a little breath in the law for some judicial discretion.
I would support you on that line because I was now about to intervene and proffer to you that my defense is being circumscribed to 2 or 3. And would that not run afoul of the due process and then my ability to enjoy fundamental justice and a fair kind of...
So whilst I could argue that and say no, I think that the removal of the word only might assist us all to come on to the same position.
So, honorable senators, I think at this stage, for my edification,
Yes, ma'am.
at 79J, we have amendments circulated. Everyone had agreed to that. And for 2, we are now going to remove the word only.
Yes, ma'am.
Yeah?
Yes, ma'am.
Okay. All right. And we are now moving on to 17. Senator Mean, at
Yes.
some point, there has to be enough discussion on a clause.
I am sure, which
All
is
right.
why this should have gone to a joint select committee.
Yes, but it
we are
hasn't,
here.
and we're here.
Madam President, Madam Chairman, through you, the Attorney General, there are instances in law where you would say something that gives a sort of a catch-all, and so where you can say if the person, the offender, can satisfy the court that XYZ or something like that. And that is what I would have liked to see added in. And I appreciate the removal of the only, but I really feel it should have something additional to allow that discretion, explicitly allow that discretion, so that the, offender or the defendant and so on could satisfy the court that he was not, in fact, in breach of the law.
Thank you, Honourable Senator. It's true that there are sometimes catch-all phrases. In this instance, deletion of the word only and keeping it strict to the concept of the tie back to the new section 20A that we'd be inserting via clause 9, where we deem an owner liable for something, the two would be read together, because ultimately your defenses are going to be prescribed by the concept of ownership. So I feel that I feel that the clause with the deletion of only alone should take care of it. And Madam Chair, if I may just put the one point, a joint select committee could never have the views of all senators.
Sure. So we now proceed with 79 key. (79L). Okay. 79K.
Madam
Senator
Chair, to the
Shriti
Honourable
Soon.
AG, thank you, Madam Chair. I was just asking for the rationale for the 45-day period between post the deadline for payment of the offence and listing the matter.
The rationale is to factor the transmission time of the whole thing moving in arrears. If you take it chronologically, you pass the traffic light, the picture is snapped, somebody then goes through the processes, the event is then issued in the course prescribed, it has to get to someone, there may be service time via mail, etc., and then you want to give people an adequate opportunity to deal with it. So actually the original prescriptive time that was offered was very short, it was about 14 days. But inevitably, it didn't factor how much delay is potentially a problem. And when we looked to the Jamaican experience, which runs a system like this, sometimes there's a breakdown in their technology, and they have to do it manually as opposed to electronically. And it was to factor all of those vicissitudes that we went with the larger time frame. It was to provide more opportunity to the violator to be aware of what's going on, because the certainty of that transaction now flows down to the licensing authority.
It's 3 months post the last day on which the fixed penalty is payable. So which means it would have already gone through the entire system, and everybody would have been served, and everything would have been done, and you would have given the offender 30 days. So now you're giving him 90 days in addition.
If I could answer this, what could the mischief be in giving more time? Couldn't the mischief be in giving too little time? If the certainty of the violation results, you can't run away from the money, you can't run away from showing cause at the licensing authority, how could one possibly complain in terms of a mischief in law that giving too much time is offensive?
The point, Honourable AG, is not mischief in law. It's just that what you're seeking to achieve in terms of a driving culture and a change of even driving habits in Trinidad, what you're doing is now saying if you're an offender, you've been served and you have 30 days to pay the penalty, and now you're saying if you're contesting it, you now have 3 months post. So you're looking at probably 6 months down the road before it reaches to court.
As this reaches critical mass, we have the opportunity to tighten. If we start too strict and the system can't work because there are incongruities of time and service and technology versus manual, then we're inviting ourselves to fail too early. So I respectfully propose to take the larger approach and work my way back so that we can then tighten the culture as we move along. This is a massive paradigm shift in our country right now.
79L. 79M.
Sure.
Senator Shriti Soon. Senator Shriti Soon.
We on it.
Madam Chair, to the Honourable Attorney General again, 79MD.
B or D, sorry.
79MD.
D as in Delta,
right.
Yes.
The red light camera was operating accurately at the time the photographic image or video recording was captured. I'm unsure of the objective way in which you're going to measure this or certify this so that, and I'm saying it entirely, so that both the offender and the state in this case, or the inspecting officer would have information to certify this and how it's going to be made available to someone in terms of a defense.
Sure. First of all, there's a presumption that it's working. in this laws we've built. Secondly, there's a process for certification and inspection by the authority to manage the red lights and the camera equipment. Thirdly, we borrowed from the architecture that we prescribed for the speed guns and the breathalyzer equipment, calibration, certification, etc. Fourthly, it is always open in a contest to challenge the validity of the equipment and to have someone prove that the equipment was actually functioning. Where is the certificate? How often was it maintained? Has it been prescribed, etc.? So there are mechanisms which articulate together with this in the current law and in the bill as proposed, which take care with this rubric, and it fits in with the approach that we've legislatively taken as a country on the successive introductions of various technology along the way.
I have a concern with it, but I think it's also addressed later on in another clause, so I'll probably raise it under that clause as well.
Senator Mahabir?
Yeah. Thank you very much, Madam Chair. And I want to elaborate on a point of Senator Srikisun where he is referring to 79MD. But I would want to relate A and D together. Honorable Attorney General, 79MA states that the inspection officer is certified by the Commissioner of Police as trained to analyze the information captured by the red light camera. So this particular bill implicates the Ministry of National Security. The Ministry of National Security must be involved in enforcing this law, this traffic law, and at the same time, under 79MD, the Ministry of Works will be involved with respect to maintaining the infrastructure, the hardware. So what I am unsure about is, and I am unclear as to whether the training program that is certified by the Commissioner of Police will be available to me for perusal. Will I be able to see it as a member of Parliament to say, I think this conforms to international norms and standards? Because when we are analyzing photographic images, it's very similar to the field of radiology, where we are analyzing X-ray images. So it, in my mind, requires some particular level of skill. And in the public interest, I would like to be convinced that the training that is offered by the Commissioner of Police in his training academy is consistent with international norms, that the Commissioner of Police, nowhere have we voted funds for him to implement such a training program. So I am not sure as to how this particular A is going to be implemented, or whether this law is going to be in abeyance until it comes. So that the clarification on A on that, and also the maintenance aspect on D, are things I would like, information I would like to get on to implement and operationalize the law.
Before I call on the Attorney General to respond, I think I have to step in here and say that when we are at this stage of the committee proceedings, we have to remember that we are not discussing the general merits and principles of the bill, but the details of the bill. Senator Mahabir, what you are raising there is really outside of the remit of the bill that is before us. I understand the question you're asking, and I'm just trying to now just ask members to be careful as we proceed. I'm going to ask the Attorney General to respond, but this is, we have to be careful that we're not moving outside of the bill itself.
Madam Chair, may I need guidance? I get guidance from you?
It's fine.
Okay, but I need the guidance, Madam Chair, because I'm unsure.
I've just given the guidance, and I'm going to allow the Attorney General, I'm going to invite him to respond. Okay? And I will give the guidance as we proceed as well. Attorney General.
Thank you, Madam Chair. Honourable Senator, I think I catch the drift of what you're saying. 79MA, he's certified by the Commissioner of Police. We've cut and pasted the prescriptions and provisions for speed guns, for breathalyzers, etc. He doesn't propose that this bill, like any other part of Chapter 4850, be prescriptive in spelling the ABCs. I'm just putting it in simple language, as to how one goes about training and satisfaction, etc. The point is that there must be someone authorized and certified. And if I were to be prescriptive now, I would be technologically specific in law and have to amend every time new technology came along to change the prescriptions that go with the current law. Classic example is the Computer Misuse Act, where you are technologically wedded to a particular point. Secondly, the training and other aspects, etc., are really matters of policy. Ministry of National Security does not get involved. The TTPS is a constitutionally carved out creature, with the Commissioner of Police having authority under the Constitution as he does. Thirdly, the management of traffic lights is the Traffic Management Division of the Ministry of Works, yes, but it is also in congruity with the agencies that articulate with it, meaning the TTPS and the licensing authority. As constructed, we've kept in within the confines of the framework law, which we use as a country and have used for a very long time.
Senator Samuel.
Based on what the AG has just reiterated, I wanted to ask him what part does the Commission of Transport play in the training aspect of it? I saw the training certification is by the Commission of Police, but then you've just talked about the congruity between a licensing office and the police service and stuff like that. So what part does the Commission of Transport play
the operationalization of how we get laws to work always involves a multi-agency approach. It's the best way to get it done, because obviously if your license plate information is going to be made available in this position, it comes from the pot which the licensing authority manages at the motor vehicle registration end. The need in law to be specific in law is to put the Commissioner of Police as the person with responsibility for the certification. So there is de jure, and then there's de facto. De facto, there's a conversation that goes on with protocols to make it work, and de jure, we've put the Commissioner of Police with responsibility, as we have done with the breathalyzer equipment and the speed guns.
Senator Ramkisoon.
Thank you, Madam Chair. Through you. Honorable AG, item D. The red light camera was operating accurately at the time. This is something in the past that we are trying to ask to get proofed. As a mechanical engineer, that's very difficult to do if you don't have a daily maintenance program. And you're asking this in law, I would suggest that we probably not put this clause in, because this is something difficult to achieve.
I respectfully disagree, because there's a log as to the functionality and it's a computer system, and it's always in arrears. And whether it is CCTV footage that you use, one of the basic requirements in evidence is that you prove it was taken by someone, the equipment was properly functioning, the time, the date, and this is technology which is mapped. So you have data logs in respect of the mechanisms.
But the data log wouldn't prove that your equipment is working. It would just have a time in and time out. And that's what we're trying to see here when you're giving the remit of the inspection officer. You had said it when you responded about the breathalyzer equipment, because what agency is really going to be certifying these equipment? And we're looking at traffic light systems. To put this as part of the law, you're putting the inspection officer in a very uncomfortable situation. I'm talking about the quality assurance and quality control of this system that you're saying is logs, but that's totally different to saying that this equipment is functioning. I don't know if you understand.
Madam Chairman, did I catch your eye?
Well, Senator Sobers has long before, so I just want...
Certainly.
Yeah, okay, he's deferring to... Yeah.
Thank you. I think perhaps if I say this, it might make it easier for us all to understand. What is coming out, what the product that will be coming out from the cameras, as I understand it, Honorable Attorney General, is a computer-generated document. And there are already processes in place for the admissibility of this kind of material in the courts. So this is simply another kind of computer-generated information? Is that what it is?
Yes.
So then it simply needs to comply with the conditions of the Evidence Act, perhaps?
Yes.
Thank you.
We borrowed the prescription here from the same construction, again for breathalyzer, again for speed guns, to put a positive statement in the law that it must be working and that you must have some form of record and proof that it was working. So the standard operating procedures and the maintenance logs, etc., have to be built out so that they can justify that this thing was constantly reliable. And if it was not, well, then the evidence falls apart.
Thank you very much.
Grateful, Madam Chairwoman. As it pertains to the admissibility of that evidence, when one reads that particular section 79M, the photographic image itself, and subject to correction, lacks a provision to allow the inspection officer to actually come to court to be cross-examined. So similarly, in terms of a breathalyzer, the technician who draws the breath from the defendant, he has to be present in court for the breath test to be also cross-examined by the defendant. Is it that we are putting the defendant at an undue disadvantage by that particular individual not being present in court? And secondly, I also have a difficulty with the term, prima facie evidence of the matter stated in the certificate. Such would be rulings that I guess the adjudicator, the magistrate, would have to treat with. And I think this is pulling that ability away from the magistrate.
Sure. Let's start with the end of the submission. The prima facie evidence is the same for the speed gun, the same for the breathalyzer. Secondly, when you issue a notice to contest, it's when you trigger the mechanism for persons to come to court. The prima facie is simply one which prevails until you contest otherwise, and there's nothing to stop you in the mechanisms of the rules of court and under the Summary Proceedings Act or otherwise to call in the evidence that you wish. So you can have the person attend to be cross-examined if you choose, but it stands exactly as we do for the speed guns and for the breathalyzer as a prima facie instance.
So the cross-examination or the attendance of the inspector, the inspection officer, would only occur subsequent to
when you
notice
challenge
being filed?
it. If you say that you want to challenge it, it's challenged.
And he would in fact be present in court.
In the same way that it's done for the speed guns and for the breathalyzers.
But I respectfully disagree because I know for a fact in terms of the breathalyzer.
Okay, let's stick with speed guns.
Right, so not the breathalyzer.
I'm trying to tell you that the concept of prima facie in law is, it's on the face of it good, but if you challenge it, then it no longer stands as evidence of a certification of fact. It's open to challenge.
No, but in terms of the actual attendance, so I'm
if
not.
it's open to challenge, you challenge it by way of cross-examination of the person who is involved in the position.
Correct, but the thing is, in terms of the breathalyzer, the technician is actually present there before a challenge is even mounted.
The mischief in law that we're treating with is the automatic availability of resources on every notice to contest. The rules of court allow you to take whatever process points that you wish. So it doesn't exclude your ability to cross-examine, but there's no need to prima facie disturb the certificate unless somebody chooses to do so. So a skilled lawyer may wish to call the person every time, but somebody may wish to not do it at all. So we're putting the burden upon the person who wishes to challenge to take whatever array they wish to do to to prosecute their defense. So it stands within the four corners of the existing practice of law.
All right, Senators, I think it's time to move on to 79M. Senator Amin, is your question, because we've had extensive discussion on this
Concerning
particular clause.
79M, yes.
Is it okay, but we've dealt with it, so this is the last question, members, on 79M, please.
All right.
Senator Amin.
Madam Chair, my question is whether we can insert something to give the public access to the record upon request.
It's implied in the statement of law, Madam Chair. There's nothing which stops disclosure of evidence. You see, we can't be prescriptive with the rules of evidence and disclosure. The practice of law still prevails. You cannot be subjected to something and just throw away all the rules of evidence and judicial process, etc. So that stands separate and apart from
That
this.
the public can...
Well, it's not the public, it's the
Well,
person who's
the person, yes, of
subjected
course.
to the difficulty. So there's no need for the public per se to know.
Not the public.
It's,
of the
if your
person
question
before
is,
the court.
will somebody be interrupted in the standard rules of disclosure? No.
I just wanted to know if the standard rules of disclosure apply.
79N. Senator Mahabir.
Yeah, 79N, Honorable Attorney General, refers to a matter I referred to earlier. You see, it says in proceedings for a traffic violation under this section, where the credential, that is the certification of an inspection officer, is reasonably brought into question. You see, I need some guidance from you, Attorney General, on the conditions under which the credential will reasonably be brought into question. Is it that you're considering only a fraudulent certificate? Is it that someone can argue in court that this officer was not properly trained according to international norms? See, and that is a justifiable defense. So under what conditions? Because M and N go together.
Answer is all of the above. Language is specifically wide to allow for the evolution of the law and to not prescriptively limit any defense or prosecution of a defense.
AG, it is a defense that someone can suggest to the court, indicate to the court, that the officer in charge, inspection officer, was not properly trained.
Of course.
Very well.
If someone wishes to take that point, they can.
79O. Senator Richards.
Thank you, Madam Chair. Honourable AG, through the Chair, could you just indicate two quick questions in terms of the part of the 79O, where it states that it was operated, and I'm quoting from the fourth line, shall not be required unless evidence that it was not properly in proper condition or was not properly operated at the time the traffic violation has been adduced. To whom, if the defendant wants to ascertain that this is the case in his defense, his or her defense, to whom should they make the request for that information and by what mechanism?
Sure. I apologize to honorable members, but it's court process.
Okay, fine.
So this is done in a forum. Your attorney, when he or she reads this particular process, will understand that there's a particular course to be adopted. You traverse those courses, you call it into question, it's now in the record, and then you proceed. So there's a whole standing several hundred years of process that has developed on this particular practice, and it's well established in law. I know it's not prescriptively set out, and that it may cause some difficulty for those who are not in the forum all the while, but there's certainly the provision that you just take certain steps, and once you trigger those steps, you proceed along that line.
My questions for you, Madam Chair, simply, I know members of the public are looking on, and they share similar concerns.
Well appreciated, Senator. It's a very good point.
79P.
Yes, Madam.
Yes, Senator Ma.
Madam Chair, 79P, sub 1 and 2. I'm seeing here where we are being told that information that is sent to the court under 79L shall be sufficient evidence to call upon the person charged to answer. Now,
Senator Mark, what is your question? Because I think it is clear what the section is saying. What is your question to the Attorney General?
I don't understand. I thought we haven't. This
Sorry.
is a committee stage.
We understand. Sometimes the run up to the wicket is a little long, but we understand. I don't mind, Senator. Please proceed.
No, it's not you. I'm not talking to you. I'm talking to your chair.
Yes.
No,
And I said nothing about a run-up to any wicket. I just asked.
I apologize,
that you just
Madam
pose
Chair.
the question.
A little spin
Senator
bowling
Mark.
helps at times.
No, it's not a question about posing the question.
It actually is.
Well, Madam Chair, if it is that you have to just pose questions.
Okay, Senator Mark, until you formulate what it is you want to ask the AG, perhaps anyone else has an issue with 79P?
I don't understand what this committee is about. We are supposed to be dealing with details of the bill. I'm asking and I'm making my submission, but you are telling me, that is the chairman, how I should do my, nobody can speak for me. I feel sometimes, Madam Chair.
Senator Mark, please, members. Senator Mark, there is no need in discussing, let me just clarify, so I will give this ruling. We are dealing with the details of the bill. Everyone here, including the Attorney General, has a copy of the bill before them. So there's no need to read the particular clause that you're dealing with. In fact, the side note says no complainant in proceedings. Can you put the question to the Attorney General on the particular clause? That is what I'm asking.
I think if you give me an opportunity to make my submission, we will save a lot of time. Madam Chair, what I would like to submit to the Attorney General is that under 79P 1 and 2, there appears to be a breach of the separation of powers in these two sections of 79P. I was about to ask the Attorney General whether the Attorney General, in this instance, when we talk about the sufficient evidence, right? I thought that was a responsibility for the court. And I'm seeing where we are advancing here that once a person is charged, there is sufficient evidence that the person ought to answer. And I'm advancing that appears to me to be a fundamental breach of the rule of law and fundamental justice. And I thought that was a discretion that was given to the courts to determine, and not, for instance, for the legislature to legislate. And that is why I was saying, first of all, it appears to me that something appears to be wrong with this particular 79P1. And then when I go to sub 2, Madam Chair, I'm seeing where they are saying that there's no need for the person to be in the court. There's no need for my presence.
No.
And
I'm saying that, that the principles of fair trial, of a fair trial, and the fundamental principles of justice guarantee under Section 5(2)(e) of the Constitution that I have a right to a fair trial. So these are two areas that I wanted to put to the Honorable Attorney General and to express my reservation as it concerns those two sections.
Attorney General.
Madam Chair, could I just ask for a bit of clarification from the Honourable Senator? Thank you for your contribution. In 79P2, where does it say that you, the defendant or the violator, is not required to be in court?
No, I'm talking about the complainant.
Oh, sorry, I got you wrong when you said that I was not required and my rights of due process.
No, the complainant.
Oh, I see, very different submission.
Complainant.
Does your submission still stand in that regard?
Yes. I'm saying that I believe that, for instance, the complainant has a right to be present.
The complainant is the policeman, you know.
Right,
Yes.
Attorney General, that is what he's asking.
I
Senator
see.
Mark is asking about whether, how is it that you can legislate to no longer have a complainant present?
Madam
That's
Chair,
one of his questions.
may I ask for your direction on this? Are there any other views on this so that I can address them in a wholesale fashion?
Senator Mark has asked a fairly exhaustive question, and I think your answer, once it is given, I doubt that anyone will raise this issue again, and we'll move on to other questions.
Sure.
if
Okay.
any.
But
Madam Chair?
No, let's deal with it one at a time, Senator
Sure.
Chute.
Sure.
Yes, Attorney General.
That's why you wanted.
Respectfully, Madam Chair,
Yes.
I'd actually prefer to hear the views
No,
of the Senate.
let's hear, please answer Senator Mark's question, and then we will deal with it. And if I could be allowed to continue to handle the proceedings, please, members? Thank you. Attorney General, Senator Mark.
Thank you, Madam Chair. First of all, Senator Mark, the complainant is not the defendant, so we've traversed that point. Thank you for agreeing with me on that. Secondly, we've lifted from the Canadian jurisprudence in this regard, and the position is actually that we are reading the law as a whole. So 79P is going to be referenced back to all of the other circumstances where a violator can call for the persons who are along the chain of this event to be interrogated. One must remember that what we're dealing with is the technology. So we're applying technology, and the real personalities to be dealt with in this forum are the persons who have conduct or control of the technology, hence the ability for the inspector to be brought to court, for the challenge in respect of the technology working or otherwise in the sections that we've just traversed. The presence of the police complainant as a person who has lawful capacity, as opposed to a virtual complainant who is the real person, who is the victim, who the police then sits over, is to be appreciated in that context. It was bearing in mind that we were attempting to use technology and that we've preserved the opportunity for the persons who manage or control the technology to be brought before the court by only providing for a prima facie standard, which if disturbed then falls apart, and then you bring the other people in, that we saw the focus really being upon those people as opposed to the strict need to bring a policeman to court every single time when he had no real part in the process.
Senator Cho.
Thank you, Madam Chairman. Honorable Attorney General, I was wondering if perhaps if we added some words to subsection 2, that it might make it a bit clearer.
Sure.
One talks about the information being provided to the court as being sufficient evidence and so on. If we say in subsection 2, after the words, the court shall not require the presence of a complainant, but this does not prevent the person in receipt of a citation from summoning any witness, that might allay some of the fears about due process.
Eminently reasonable.
It's just a suggestion.
In my mind, I wondered whether shall should change to may, but then it collided with notwithstanding. But that formulation of words is very attractive as well.
Senator Chute, may I have information of the words, please, so we can record it?
Yes, Madam Chairman. Shall not, after the word complainant,
Comma.
yes, but this shall not prevent the person in receipt of the citation from summoning any person in his defense.
Excellent.
The only other thing is, having now called it out, Madam Chairman, I'm wondering if the word debar should be used instead of prevent.
Yes, ma'am.
I don't.
Okay,
Thank
so
you.
may I read it? Over?
Yes, Madam Chairman.
Notwithstanding any rule to the contrary, in proceedings for a traffic violation under this part, the court shall not require the presence of a complainant, but this shall not debar the person in receipt of the citation from summoning any person in his defense.
Yes.
Okay, so
thank
that
you.
is the amendment
May I
as
propose that
proposed.
amendment?
It's a materially attractive proposition.
79Q. (79R).
79R?
Yes, Senator
Yeah.
Mahabir.
Thank you very much, Madam Chair. 79R2, Honorable Attorney General. The owner is liable to pay the fixed penalty plus 1/2 of the amount of the fixed penalty. And I would think, in the interest of fairness, that the owner should be allowed to show cause, so that if he's out of the country, he breaks a red light today and he flies out tomorrow and he's back 21 days later. If he can show cause to the court, then he should not be imposed with this penalty of 1/2 of the amount. He should just be given the fixed penalty. Why not just show cause? I think that would be fair.
The objective of the law is to cause compliance. Showing cause perhaps betrays the fact that you have a whole process prior to the sum becoming due. So 79.2 is on the back of 79.1, where an owner does not pay the fixed penalty and does not file a notice to contest in that rather large time that Senator Shriki pointed out. So you got a whole lot of time. You chose to do nothing. You're going away in the example that you've given. I respectfully don't think that there is any reason to cause a court to stop and now hear an application for show cause, because then we're going to go back into the system of bringing these violations into judicial process, which really will occupy court's time, where somebody has had so much opportunity and ample opportunity to just pay.
(79S). (79T).
And T, Madam Chair.
Yes, Senator Mahabir.
79T3. The licensing authority shall inform the owner of its decision in writing as soon as possible. I don't know what as soon as possible means, AG. Should we not impose a time limit? Since we, the people, are called upon to pay our fines within a specified time, the authorities of the land must also be similarly disciplined. So should it not be within a 45-day period, a 90-day period? What is as soon as possible? It is vague. I do not know if it makes sense in the law. It makes no sense to me.
Attorney General.
I'm smiling broadly, Senator Mahabir, because this is a concept which every individual has, and rightly so, as to the state's responsibility to act. The as soon as possible is really intended to be in law as soon as is reasonably practicable. And it's a feature of almost every single position where the state has to comply with something. And what you're saying is a constant complaint by many in society, but the point is, even though the state has supposedly a greater resource base than the individual, it seems to be inversely proportionate to its efficiency. And in those circumstances, as soon as is reasonably practicable or as soon as is possible is put in recognition of the inverse proportionality of efficiency to size.
Honorable Attorney General, is it not the intent of legislation not only to ensure that the citizens comply, as you indicated to my question prior, without showing cause, but that the state too should be also made efficient? The state must follow the law as I must follow the law. And so my point is, I would like very much to see a time limit. Is it a 90-day period? A 45-day period? Because as it is now, this law is going to actually facilitate greater and greater inefficiency in the transport department, and this I cannot support.
Sure. Perhaps I could answer this way. Subclause 3, which you've referred to, again comes on the back of 1 and 2. The imposition of sanctions by the licensing authority, which is what 79T deals with, is that an owner may show cause in 1, why the authority should not impose. 2, After consideration of representations made by the owner, the licensing authority may impose any combination or decline to impose and require the owner. 3, the licensing authority shall inform the owner of its decision in writing. So the violator is not subjected to a confirmation of liability or exculpation until that violator gets it in writing. So there is no jeopardy to the violator in the state taking its time. If anything, there is a luxury if the state never does it at all. So because there is a coincidence between the decision and writing, the two are not divorced. It isn't as if you're getting a decision and then you're getting the reasons later. You're getting the two in coincidental time.
No. That explanation, no, Madam Chair. If you're telling me now that if the authority doesn't write to me, that is a mischief.
How?
Because then all these violations that we're sitting here for hours to do, they could just never write to me.
And then what
I can
happens?
never get a citation, and then I done nothing.
No,
'Cause I'm a
we're
friend.
talking the licensing authority imposing a sanction which flows eventually to it after a process, tells you, show me cause why this should not be applied. And if you go through the process, in subclause 3, they must give you a decision and they must give you that in writing. Until you get it in writing, there is no crystallization of anything at all. So what is the mischief that you're referring to?
Right, so if I am in collusion with a officer of authority, then you may never write me because you're my friend. And that is the
That's
mischief.
the mischief.
So you should
So
give them
what
30
happens,
days.
Senator, what happens if I'm in collusion and you're my friend and I have 30 days to respond or 90 days or 120 days and I just don't do it? How does that change your example?
It doesn't change.
It facilitates it because I'm now out of the time frame and it's gone forever.
But you would have somebody to be auditing you,
What's
right?
the-
And
what-
then you would have.
But the audit applies whether you have a decision in writing or a time
Right,
frame.
and if you do audit me and you don't have a time frame, I could say, well, I'm getting to it.
And then what do you do
And-
when that happens?
Well, right, the auditor's left in a position that they have no other choice but to believe you. But if you put 30 days, they can come and say a month has passed and Senator Ramkissoon has not been received her
Senator Ramkissoon,
writing.
what happens if the time frame is so carefully crafted that nobody can comply or there was some cause, etc.? It is by far more reasonable in the example that you have provided to make sure that the decision is in writing and that the two coincide in time. Therefore, the prejudice to the violator is carefully managed. In the example that you've given where the person gets off the hook because they're in collusion, it applies whether you have a time frame or not. And it applies whether you have an audit or not.
But if there's a fear for the time frame, then put a fair time frame that we have used in this bill, which is 3 months.
The time frame
And
which we propose is the formula here, as soon as is possible.
Through you, Madam Chair, Honorable AG, my only difficulty is that not having a time frame could also act as a inordinate guillotine hanging over the neck of the person who wishes to move on. I mean, I know there are many persons in society, no matter how small the sanction could in fact be, they would just want to have the situation dealt with. And far too long has the state been given an inordinate wherein simply an extension of time requested by the state to treat with the matter.
So what's the proposal?
The proposal is just to put a time frame, maybe 60 days, 90 days, some type of time period to have the state be able
Our
to-
position in relation to the prescription of a time frame is that the formula proposed is reasonable, and the rationale for that is that if we put in a time frame which cannot meet every circumstance or the vicissitudes of how a matter may work itself out, then we're going to have does it apply or not? Is it valid or not? Is it past time or not? And in these circumstances, we prefer to allow for the rationality of position being the wording that we propose, but specifically the guillotine may also be a feather, because you may have no sanction at all.
Yeah, but equally, the fact is that it is a sanction, and I would like to know.
Or it may
what
be
the
no sanction
is,
at all.
And it may be no sanction so that I can move on with my life. I mean, I don't want to.
Yes.
Yes.
Okay, finish your point.
I don't want to trivialize the situation
Sure.
because it's just a motor vehicle offense. I'm
No,
just
no,
saying,
it's a
but-
serious submission, I
Correct.
accept.
But at the same time, I just think some time frame should be.
Have wrestled honestly with this position of time frame, not only in this legislation, but in many other pieces of law. And the prescription offered is the reasonable time frame as it's done, as soon as is possible. Try as I may to get away from that, the vicissitudes and the idiosyncrasies of institutions crawl in. And whilst I hear you, I have seen it whilst I was in opposition, and now while I'm in government, that this is the formula to be adopted.
The only incident we have will be after the word complainant.
All right, so
Questions?
that's T.
Questions?
So now, honorable senators, I crave your indulgence because we are now going to vote on clause 35,
34.
34, and there were several amendments made on the floor. Okay, so honorable senators, the question is that clause.
Clause 34, yeah.
All right.
Well, I was
All
just-
right, just before, if anyone, I did not see, I don't know whose device just went off, and ordinarily I will say leave the chamber for 5 minutes. I will leave it alone. Please don't let anybody else's phone go off for the rest of the day, please. So the question is that clause 34 be amended as circulated and further amended at 79J2. We're dealing with circulated and further amended in that circulation at 79J2 by deleting the word only, and that it be amended at 79A by deleting the word prescribed and putting approved. Am I correct? Yes. And by deleting the word minister and replacing with authority. That's 79A. Then 79H. By deleting the word at 79H1A, by deleting the word member. By deleting the words member of his family. Yeah? 79I, no, that was secluded. 79J.
J2.
2, by deleting the word only. And 79P2 by inserting, by taking off the full stop and replacing it with a comma after the word complainant and inserting the following words after complainant, but this shall not debar the person in receipt of the citation from summoning any person in his defense.
Citation notice, please.
So that, let me reread 79P2, where after complainant, we put a comma as opposed to a full stop, and continue with the words, inserting these words, but this shall not debar the person in receipt of the citation notice from summoning any person in his defense.
Yes.
Those in favor say aye.
Aye.
Those against say no.
No.
The ayes have it. Section 34, as amended, now stands part of the bill. Clause 34, as amended, now stands part of the bill. Clause, yeah.
Clause 35.
Honorable Senators, the question is that Clause 35 stand part of the bill. Senator Choate.
Madam Chairman, I'm looking at what has been circulated to us as a new 87A, which talks about the suspension of the driver's permit where someone is charged with manslaughter. I have a few comments with respect to this and some queries. It starts off by saying, if and when any person is charged with manslaughter, should it not be, Honorable Attorney General, simply where any person is charged with manslaughter?
It can be, Senator Choate. What we did is we lifted from the existing law, but we can tidy it up, yes.
Yes. And it shall be lawful for I don't think we should have the licensing authority having the power to order the suspension of the permit, because you have one state agency, which is the court, dealing with the person charged with manslaughter. So it might be neater for the legislation to say it shall be lawful for the court to order the suspension and then amend the subsection 2 accordingly. Because as it stands, you have the person, you have the licensing authority, you have the constable, who then has to take the permit to the clerk of the court. Now, this could potentially be very serious because your driver's permit is a form of identification. And if you have this document moving through 4 different persons in the system, it means that your driver's permit could be used for fraud and other purposes. So I'm respectfully suggesting or proposing that first of all in 87A(1), we remove the words if and when and replace them by where. Sure.
I did take, please proceed.
And I'm also suggesting that in the 5th line, that the words licensing authority be removed,
Court.
and we put in,
The court.
replace it with the court. And subsection 2, if I may respectfully propose, any such permit so suspended under subsection 1 shall, and then the words on right down to the word permit, I'm proposing that those words be deleted.
And it would read in what final form?
It would read, any such permit so suspended under subsection 1 shall be surrendered to the clerk of the court before which the person so charged is to appear. There are 2 other proposals, and I'll try to make them very quickly. As we have seen in France and England, motor vehicles may be used as weapons. So I'm respectfully proposing that in subsection 1, where any person is charged with manslaughter arising out of the use of any motor vehicle, that we insert these words, or offense committed by the use of the motor vehicle as a weapon. and then it continues with the rest of the subsection. And finally, because our system is so slow, and somebody who's been charged with manslaughter is not likely to have his first hearing in the assize, probably until 5 years or more have passed, I think it would be too onerous to suggest that this suspension should remain for 5 years. It seems to be disproportionate. So I'm respectfully proposing a subsection 3 to say that where the court exercises its discretion to suspend the driving permit of the person so charged, this decision shall be reviewed on every occasion that the person appears before the court. So those are my proposals, Madam Chairman.
Thank you. May I respond through you, Madam Chair? Honourable Senators, the circulated version for the inclusion of Clause 87A really triggered as a result of the bill proposing in Section 35, Clause 35 at page 21, that we repeal the whole of Part 6 and substitute a new Part 6. So what we unwittingly did was we deleted this provision which appears in the Parent Act as Section 87. The language which we proposed, which appears in the draft circulated, is word for word the text of Section 87 of the current law. Senator Choate, thank you for the very interesting reflections, particularly in light of what we are watching the world dealing with now. And I can say that we in Trinidad are also equally mindful of the consequences of terror, which can manifest itself in mechanisms such as this. So it's a really very interesting approach for consideration, and I compliment you for that. I personally have no objection to the improvement of the old, or rather, of the existing law in circumstances proposed, and I think it makes for good law. I welcome, of course, however, through you, Madam Chair, the views of the rest of the Senate on this particular position.
Senator Mahabir.
Yeah, thank you very much, Madam Chair. Madam Chair, I want to go back, as you did prior, to following the subclauses, so I want to go back to 81. We are on Clause 35, but it's 81.2. And 81.2, Honorable Attorney General, says that the constable finds a vehicle and he has reason to believe that a traffic violation is being or has been committed in respect of that vehicle. The concerns, of course, I had raised in the debate is that I don't know what reason to believe is, given, of course, our problems we've had with the day of total policing, but that I'm sure you have given due consideration to. The issue I have is one of fairness. You see, there is no time limitation with respect to committed in respect of that vehicle. So it could very well be that the constable has reason to believe that this offense was committed 3 years ago as opposed to 3 months ago. And so I would like a time limitation within which, having had that time elapse, the constable is not authorized to impose on a parked car any fixed penalty ticket, like a 90-day period, given change of ownership over a 3-year period. Yeah.
Understood. Madam Chair, may I just ask procedurally before we get to the answer which you may permit to 80. Are we going to take the same approach that we did in Clause 34, where we start with 80 first and then work our way up to 81, etc.? Do you wish me to answer Senator Mahabir's point now, or hold my... But sure.
Point.
Okay,
yeah.
Thank you. Senator, thank you. A fixed penalty offence, now a violation, for which this mechanism kicks in, is an quote-unquote as close to on-the-spot occurrence as possible. Further, there is a prescriptive period for summary offences that previously prevailed, and that's a 6-month period. So the 3-year positioning is out of bounds. Secondly, the reasonable belief is the mechanism by which we provide for malicious prosecution. So if you lack reasonable approach, you can find yourself on the other side of the law where you are met with an application by a person who's been a victim of malicious prosecution for a claim in malicious prosecution, which can be for any of the matters, including this. So it's prescribed in terms of the operation of law, and the clause as drafted meets with the currency of how the law operates right now. What we're doing is we're just tightening up the whole concept of fixed penalty enforcement, which exists in law right now. So we're repeating a lot of the provisions in law, but tidying up the section to correlate it to violations and other aspects as well.
I want to put my position on the record for clarification. No constable can affix a notice of penalty to any windscreen of any car if that particular event occurred greater than 6 months ago.
Correct.
Thank you very much.
'82.
So we passed 80, right?
Yes.
Okay.
Gone to 81, 82. '83. '84. '85. '86. '87. This is where we have dealt with Senator Choate's proposed amendments. Yes? Attorney General.
Yes, Madam Chair. As I was saying on 87, I think the recommendations proposed by Senator Choate are very laudable. It allows us to improve what is the existing law in the existing Section 87, which we're proposing to insert this way. We've omitted to describe that the marginal note should be there. So if I could just for the record reintroduce what the marginal note in the old 87 was, which is temporary suspension of permit pending determination of charges. So it's temporary suspension of permit pending determination of charges. And the government is quite pleased with the recommendations for the improvement of 78A in terms recommended by Senator Choate.
Senator Samuel.
Sorry about that. 83, 3B, where it's supposed to change to 88B and not 88C.
Thank you, Senator Samuel. Senator Samuel is referring to
The amendment is circulated.
Yes, ma'am. Thank you.
Yeah,
Appreciated.
yeah.
Madam Chair,
Yes, Senator
through you,
Robinson.
I know we said we would deal with the 9th schedule, but in 84, it speaks about the fixed penalties. Sorry. In relation to the 9th schedule, I know we said we will leave it for after, but in this particular 88, it speaks, not 88, sorry, 84 speaks about the fixed penalties as opposed to the Parent Act. I'm not sure if you would like to explain it now, because this one says the fixed penalty for the traffic violations.
Sorry, which clause are you on? 84?
Senator Ramkissoon, you know we've passed 84.
Oh, yes.
Is it that you're asking, what is it that you need?
In terms of the 9th schedule, which we're not dealing with, we're asking to pass this in relation to the fixed penalties. And I'm not sure if we got an explanation on that.
Sure. Perhaps
Or maybe I could add, some of the, in the 9th schedule, some of the violations did not have a fixed penalty.
We've
and
addressed
some
those.
had.
we have them in the draft, which we'll come to. We'll actually deal with the schedule separately when we come to it. 84 is just the springboard by which the schedule comes alive.
Right, so if we're asked to vote on this, this means we're accepting the 9th schedule?
No, we still have to get to the 9th schedule, and as we go through the bill, we'll come to the schedules last. So what 84 does is that it simply allows for the force of law for the 9th schedule, but we have yet to come to the terms of the 9th schedule.
Okay, thank you for your
Today, we'll be dealing with that
clarification.
in just a little while.
Okay.
All right.
Sorry, Madam Chair.
We are now at 87, and I think, Attorney General, you have agreed to incorporate what Senator Choate has proposed?
Yes, ma'am.
All right. And someone has recorded that? Yes?
Yes, ma'am.
88? Senator Mahabir?
Yeah, thank you very much, Madam President. On Clause 88, Attorney General, minor point on 88B, I assume I don't know that the licensing authority will have an electronic record of someone's driving record as opposed to a manual. So that is an assumption. But really my substantive point is with respect to 88.3A3. And it says that the licensing authority may suspend the driving permit of the driver or owner, as the case may be. But I am not seeing the circumstances under which such a penalty may be imposed. It says it may, and I would have liked to see that it may suspend, despite repeated warnings, that the driver has been given a few warnings, and then once he has failed to comply with the warnings, then the licensing authority, acting on the authority we give in the Parliament, may suspend, because the suspension is a very serious action. And this may is very vague and nebulous. So is it that you will consider that the driver, the errant driver, is cautioned, and his failure to acknowledge the cautions or accede to them will result or can result in the ultimate suspension of his driving privileges? But as you see, may is really very vague, hanging there, subject to judgment and to some corruption.
Sure, I understand. Honorable Senator, Madam Chair, may I? Yes. Honorable Senator, thank you for your inquiry. I'd remind that the law must be read as a whole. So, to answer your first point, which was on the electronic, it's a matter of fact there is an electronic record. So that's the current position. And the Data Protection Act will also require that you have manual records as well. So they're both. Secondly, the law must be read as a whole. When we get to page 29 of the bill, you will notice that there is Part 6A, Legal Proceedings, Demerit Points, Suspension and Cancellation of Driving Permits. And I'll refer you to Clause 88 as it will come alive. There is still the show cause provisions. The expression may is used specifically so that there is a discretion that is provided, but it is met with due process. So it is not vague. When you look to the rest of the operation of the law, so there's not the I'll warn you several times and have a record of warning you several times. We're putting the burden upon, or the onus upon, users of the road to comply with the laws. There is due process given to them. There is prescription with certainty as to what happens with them, but then they go through several layers of due process, including the show cause before you have suspension or termination or cancellation.
Thank you. Fully accepted, Attorney General.
Thank you, sir.
Ubers?
Through you, Madam Chair. In terms of 88.2. In terms of 88.2, notwithstanding Section 44, where they deal with the notice to contest being filed by the defendant, and then he or she does not show up to court, and the court having the authority not to proceed without issuing a warrant, and adjudicating upon him as if the individual was there, is it then that maybe a summons should be sent out, and then subsequent to the person not coming on that alternative occasion, the matter is then dealt with?
Sure. I'm juggling litigation at the same time while I do this. I apologize. I would remind that the current system that we're seeking to renovate is the injudicious use of court resources. What we're doing right now is reversing the position where you had to have the complainant or the court processors go and summons the offender, bring them to court, have the return of service, call them several times, have the policeman in court every single time the person may or may not come. Once you had the return of service under Section 44 of Chapter 420, the Summary Courts Act, you could proceed ex parte. We've actually now proposed an entirely different system. We're saying, if you want to come to court, summons yourself, to put it blandly. Summons yourself through the notice to contest. So there's no need for me to go and get you. You come and get me. Your summons to yourself is now at the court, and you know when you're coming to court because you've been summoned to court. And then the in absentia kicks in. If we were to hybrid or cross-pollute the position, we'd end up in the same system of having to use police resources to conduct something which, in our experience as a jurisdiction, has been shown to be effective only 30% of the time. So we've gone on the other end of summons yourself and make sure you're ready to proceed. So that's the conceptual layout of how we've now approached this end.
But just simply contemplating if the individual falls ill possibly on the date.
Which is why we've put the second round of licensing authority penalty position, because the ultimate sanction is in the licensing authority now. And we're saying you have a whole process down there where you can show cause why it shouldn't happen to you. And of course, you can challenge something, you can appeal something, you can judicially review something. If it's close enough to your heart over the issue, all of those mechanisms are still preserved in law.
Madam Chair, isn't that a power that resides in the court already? Why are we attempting to remove that discretionary power that the court has to determine for itself if a person does not turn up, whether they will pursue minors the person? Why do we want to why does the legislature want to interfere with the running of the judiciary? I think this is a matter for the judiciary. So if, for instance, I have to appear in court for whatever reason, Madam Chair,
sure.
and what is being proposed here is that the matter should proceed ex parte.
Not,
I mean, it's a,
sure, Madam,
so we.
May I address it?
I don't think that it's a fundamental breach of natural justice and a fair trial. And I don't like this argument that the AG
sure.
keeps advancing in the context of we saving time and we saving money. Democracy is very expensive.
May I? Thank you. Madam Chair, first of all, I would direct the Honourable Senator to the language in the clause, which is that the magistrate may proceed ex parte, not shall. The shall is prescriptive only in respect of the non-issuance of a warrant because you've summoned yourself. Secondly, the opposition's position in relation to this particular clause has dramatically evolved from the position advanced on the floor, where honourable senators said that this had no precedent in law at all until we refer to Section 44 of the Summary Courts Act. So I'm happy that there's been some advance in the opposition's position now that they've reflected upon the Summary Courts Act. But it is far from the position volunteered by Senator Mark, and I beg to differ with him.
Senator Richards.
Thank you, Madam Chair. Through you, Honourable Attorney General, just because I'm not a legally trained mind, and for clarity, in this 88A, in earlier discussions, there was quite a bit of focus on the ownership of the vehicle being liable. And in this part, there's driver or owner.
Sure.
Is this to differentiate that very point we were concerned about earlier?
So, may I just intervene here? We were just dealing with 88(1) and 2. We haven't dealt with 88A as yet. We're now moving into 88E. Okay, just for the benefit of all members. Attorney General, you can respond to Senator Richards?
Yes, ma'am. Thank you. Senator Richards, the response is we deemed the owner liable for red light enforcement because we were using technology, and the technology could only capture the car, not the individual. It's different for the fixed penalty, which is the policeman or agent of the state on the spot who witnesses an event and who therefore has the advantage of having the driver or owner, because it may be different.
Thank you.
So the two are different.
B. 88C. 88D, Attorney General, you have an amendment circulated.
Yes, ma'am. We propose in the circulated draft that we delete paragraph A as it appears in the bill. This is 88D1A at page 28 of the bill. And we substitute it instead with a formula. Members will note that the bill proposes that the minister may from time to time order, add any traffic violation to the 9th schedule, prescribe in respect of that traffic violation a fixed penalty not exceeding $5,000. We're proposing for honorable members' consideration that we move instead to a formula. And that formula would be that you could prescribe in respect of the traffic violation a fixed penalty not exceeding 75% of the fine prescribed for the traffic violation. This would allow for some flexibility as it moves from time to time. We're entirely in the Senate's hands on that point as to how they consider it can work. We're also proposing, Madam Chair, in subparagraph C of the same 88D1 at page 28, that we remove the expression which is not exceed $5,000 and instead move to the use of a formula of 75% of the fine prescribed for the traffic violation. We further propose that we insert a new subclause D and that we allow for the addition, alteration, or removal of the number of demerit points for traffic violations, so that we could be in keeping with the undertaking that we've given to look at the 9th schedule by way of order and therefore adjust the demerit points at the same time. And those are the proposals that we recommend with respect to clause 88D.
And then 4, you will renumber.
Oh, forgive me, D, I forgot. Thank you. That's in 88, that we, Roman 4, that we renumber, of course, paragraphs D to E as paragraphs E to F, which is a consequential amendment to the insertion of paragraph D.
Yeah. Attorney General, just one thing.
Yes, ma'am.
88D1, you talked about A. Are you including the words not exceeding, the word exceeding?
Yes, ma'am.
Is it there?
Yes,
So it
ma'am.
will read, and add any traffic violation to the 9th schedule and prescribe in respect of that traffic violation a fixed penalty not exceeding.
Yes, ma'am.
So the word exceeding has to be inserted there. Okay.
Or we could use it, forgive me, Madam Chair, just permit me one moment with my team here.
Sure.
Do you wish to use the same formula, does not exceed? Exceeding, ma'am.
Members, 88D, the proposal of the Attorney General, Senator Mark.
Yes, Madam Chair, I would like to suggest and propose that under 88D, that the order made under subsection 1 shall be subject to an affirmative resolution of the Parliament and not a negative. And the reason for that, Madam Chair, is that under 88(1), A, B, C, D, and E, the minister has a lot of space and ability to engage in all kinds of changes to the law without any reference to the Parliament, except if you are lucky to look in the Gazette and see it under negative resolution, and then you have to hustle to come here within a 40-day period. So, Madam Chair, we are very firm on this matter, and we want negative change to affirmative. That's our position.
Attorney General.
Yes, ma'am, I'm very pleased to answer this point. I'm pleased to understand that Senator Mark is now very firm on this point. I'd like to refer honorable senators to Chapter 4852, which we are incorporating now into Chapter 4850, specifically Clause 11, which has stood on the books of Trinidad and Tobago since 1984, amended in the year 2000 and again in 2010. I believe my learned colleague was in Parliament on several of those occasions. Section 11 of the current Act says, the President may from time to time by order add any offence to the first schedule, prescribe in respect of offence or penalty not exceeding $5,000, remove offences, add or remove from the second schedule, alter fixed penalty for any offence, so however not that the penalty does not exceed 5,000. Offence means in subsection 2. Subsection 3, in relation to the system of awarding penalty points, President may alter the number of penalty points for any offence howsoever. The current law as it is doesn't even meet the standard of negative resolution. It was just by order. And the regulations at section 13 were that regulations and orders, so that's at 11, circumscribed by 13, which now provides, which provides in that act that regulations and orders made shall be subject to negative resolution of the Parliament. So with the greatest of respect, Honourable Senator, the existing law has operated for quite some time. This was an Act of Parliament number 18 of 1978, and the negative resolution has worked since 1978 with the greatest of respect.
Madam Chair, we have something called the 9th schedule with what is called a fixed penalty system, which we are coming to in a short while, and the merit point system. And I can't recall, unless I'm corrected, that these existed.
Sure.
And therefore, we are not supporting any negative resolution. We are supporting an affirmative resolution.
Madam Chair, if I may address, I would refer members to Chapter 4852, where what will now become the 9th schedule is described as the first schedule to that same 1978 law, which has stood on the books since then, subject to negative resolution. So again, with the greatest of respect, a simple reflection on Chapter 4852 does not support the now fervent recommendations of my learned colleague.
Well, as you know, nothing stands still. Everything changes. And we are seeing an affirmative resolution, and we are not budging on that.
I think I've said enough.
88E.
Madam President, in relation to 88E, this was the point I had alluded to earlier with the dangerous driving and the careless driving, which is 71, Clause 71. But in this case, it says that you can go before the trial and jury, so we will leave it as it is to be determined by the courts.
Thank you, Senator.
88F. 88G. 88H. 88I. 88J. Senator Shriki-Soon, 88J.
Yes. Right. With respect to the establishment of the demerit points register, the question is, how would the public be made aware or access the register that is being created?
By application.
By
By application. So your demerits are your demerits. So by simple inquiry. In fact, what the registry is about to do, and we're hoping to conclude that within a matter of weeks, is to launch the database where every single driver with a driver's permit will have a unique identification access to his or her database of demerit points. So the technology is coming to you.
So it's an online access?
Yes, sir. And of course, there are paper backups to these systems because it constitutes information which, when the Data Protection Act becomes fully operational, will have to be paper backed.
Would you consider, with respect to the demerit register, especially when a driver is approaching a threshold where he is liable or subject to sanction, that he be informed?
He will be, because the mechanisms for suspension, termination, etc., come where you've crossed certain points. So the system is built in so that triggers are put into event, not necessarily when you're approaching, but when you have crossed. But we're working our way towards the technology. There's a lot of self-regulation that's going to happen into there. Much like the United States does, where they say Credit Karma checks your credit scores, people access it themselves to know what other people think. So there's a certain amount of push to have people deal with themselves appropriately, but they will have access to information.
Madam Chair, through you, is this demerit point register different to the database that was to be completed in 1 week's time on the Ministry of Works and Transport website?
It is not different, and in fact, we've kept it. The next stage is when we, the population, have accessed it, and access is scheduled for next week. So we are on track. I just want to remind honorable senators, this has never happened before in our country, and the licensing authority has done immeasurable work to achieve material which just simply never existed.
88K, 88L, 88M.
I think that we have to go back to the drawing board. We will not support this arbitrary. There has been no justification
Which clause?
submitted to us on this point system, where if you are charged for careless driving, Madam Chair, you lose 6 points, 1 point away from somebody seizing your driver's permit for a year, Madam Chair. I think this is a most serious incursion into people's rights and freedom in this country. My right to own a car, to drive my car in peace. And even if, Madam President, I think Ms. Senator Ramkissoon made reference to Australia, where the definition of careless driving is clearly enunciated. The Attorney General told us a short while ago that he does not want to put in the interpretation section careless driving, but there's a provision in the 9th schedule called careless driving, and I could lose 6 points for that, Madam Chair. And when you look at 88M, once you make 7 or more demerit points, Madam Chair, within 12 months, you can end up losing, Madam President, your driver's permit. And that is totally unfair. And therefore, I am saying that we should go back to the drawing board on this 88M. And not to mention, Madam President, when we come to this 9th schedule. So I just want to serve notice that this system and how it is, in fact, we don't know, Madam President, how they arrive at this. Why not 10 points, Madam Chair? In order to, why 7? Why not 12? But 7, Madam? And then it goes on. Look, this is a most dangerous invasion and infraction. And I think that we should restudy and revisit this. That is our position.
Attorney General.
Thank you, Honorable Senator. Madam Chair, first of all, 7 points applies to newly licensed drivers, in respect of which we are keeping a short chain where you are most at risk of causing danger or damage to yourself and to others. Secondly, 10 points applies in respect of the other category, and therefore it is not true to say that it is 1 point away from disqualification, etc. Thirdly, there is no right to drive in this country. It has never been a feature of the laws of Trinidad and Tobago. You are given the privilege to drive by virtue of acquisition of a license, which is by its very nature as a concept of law revocable. So there's no right to drive in this country. The right to own a car may exist, but you don't have the right to drive it. That is by way of permission, by contract and license between an individual and the state. The rationale for the prescription of demerit points has come from the international standards, and in particular our CARICOM neighbor, Jamaica, where we deal with the prescription of these penalty points, these demerit points. We have heard, in particular, Senator Shriki-Soon's ask and recommendation for when one resets the clock, and the recommendation that 3 years may be too long in the circumstances. And we propose, as we come later, to adjust that to 2 years as opposed to 3, in recognition of the merit of the point raised by Senator Shriki-Soon. In respect of the other matters raised by Senator Mark, I think I can simply say we beg to disagree.
Chair, if you may, just allow me 1 second. Madam Chair, this matter involves the police. This matter involves the licensing authority and warden, traffic wardens. Madam Chair, there has been no training as far as we are concerned. And not only that, Madam President, Madam Chair, the public, I talking to people outside there before I came here today and last week, and the population isn't aware, Madam President, of the system. There has been no education. There has been no sensitization. You're dealing with a police service, Madam President. We have heard many instances of policemen, not being fair. I wouldn't say otherwise, not being fair. You have a licensing division that the minister himself has indicated, corrupt. So we are going to put, this new system in place, Madam Chair, at a time when these institutions need a lot, or they leave a lot to be desired.
Attorney General.
Well, Madam Chair, I don't propose to enter into a debate on the policy behind this. We beg to differ with Senator Mark's position. This law has been in gestation for close to 26 years, and enough is enough.
Senator Shriki-Soon.
Madam President, 88M, right?
Yes.
Right. To the Honorable AG, through you, Madam President, 88M2A, the first tier of points for the register. 10 or more, but less than 14 demerit points. Yeah? I'm just asking if that 10 could be moved to 12. And the reason why I'm asking for the 10 to be moved to 12 is that the average number of demerit points would be 3 to most offenses. So if someone commits an offense at 9 and they get 3, they would receive a sanction, they would have a demerit point of 12, which would automatically disqualify them. But if they have 10, they already would be disqualified. And if they are, let's just say that another offense was committed, they would be 13 and still within the same threshold of 10 to 14. But if we go to 12 and they incur 3, they would move into the next bracket of over 14. So I'm asking that consideration be given to that.
Senator Ramkissoon.
Thank you, Madam Chair. In relation to 88M, and I too would like to know the explanation into why or how did they come up with 10, 14, more than 20. And just now the Honorable AG spoke about the international standards. And well, I don't know which standards you're referring to, but you did give Jamaica. So I just pulled up Jamaica's demerit system, and I saw an article from the Cleaner, which was posted in 2013, April 25th, right? The Gleaner, sorry. Thank you for the correction.
yes, and Senator-
And it spoke about license with the merits will not be suspended, because they said that the Island Traffic Authority has said it is not suspending the driver's license for motorists because it doesn't have the authority to do so. So if we're designing it, well, I only learned just now that you're designing it to this system, or I would have looked at it more closely. And if we're designing to this, and then they're saying that we're not be telling us that we're suspending your license and we're taking it away for a period of 6 months or 1 year
Sure.
or 2 years. So how is it that we're designing it a system that has failed?
Sure. Well, first of all, we didn't take Jamaica wholesale and just change the name, as is evident by a comparison of this act with that. Secondly, it's in the bill essentials, and when I piloted the bill, I specifically referred to Jamaica on umpteen occasions. Perhaps you didn't catch it at that point. I don't mean to be pejorative at all, but I did see it on many occasions. Thirdly, we've looked at a number of jurisdictions and lifted certain aspects of it. We certainly do intend to suspend in the manner proposed by the bill. In relation to Senator Shriki-Soon's position, good point. Can we get there too fast? Would we unwittingly throw people out? Some points are higher than others, but when we go through the to-be amended 9 schedule in terms of the harmony, because honourable senators, both Senator Ramkisoon and Senator Shriki-Soon and some members of the opposition bench did point out, Senator Mahabir, that there was an incongruity in some of the matters. We went back and we looked at those again and we found some of them. The rationale for the matrix which we propose is grounded in some very serious offences attracting some very serious fines. Very serious number of points. And for those matters, we do intend that you're on the cusp, watch out, obey the laws, self-regulate, lest you find yourself suspended for 6 months or a year or some other position. So it was a very purposeful approach on our part. Whether we should bump to 12 or not, I'm asking the technocratic team to look at that. They are the ones that have had a little bit deeper appreciation than I have on the point. So we're just considering that point right now and whether it might need a consequential adjustment of any other factor. It may be that we just push that lowest bar, which is 10 to 12, and that may give you some point. But the rationale behind this is really, if you're skirting on the edge of suspension, do everything within your power not to breach the law as the person with conduct of yourself. And that's where we are. Self-regulate and obey the law. Unlike Jamaica, we certainly well intend to apply this law. That jurisdiction's application of its laws is up to itself. And we spotted some of their inconsistencies and we moved around those.
Before you look at it, I was just wondering, is there any standards or benchmarks that use 10 demerit points to 6 months? Is
Australia and England in particular.
I will look at it. Thank you.
And Barbados.
Senator Mahabir? 88N. 88O, Attorney General, you have circulated.
Yes,
Madam
ma'am.
President, I do apologize. I do have a question on N.
Sure.
Okay, thank you. In relation to the reissue, I had raised during my debate the issue of the...
I'm sorry, Senator Ramkisoon, I can't hear you so
A.
well.
88 and A,
Yes.
3A, sorry, 3A, for the rehabilitation program approved by the licensing authority. And I had raised it in terms of where is this program, is this an existing program in our local system?
Yeah, there.
And this is something that they would have to pass and then go to driver's test and fee.
Sure.
Okay.
First of all, as a result of the advocacy of the court and also interest groups, in fact, sitting today for the vast majority of the time that we were here was the president of Arrive Alive, who has been following this very carefully. And Arrive Alive is one of the standing institutions that the magistracy refers drivers to, particularly young drivers, to go through courses that change their lives. So there are existing positions. We didn't seek to prescribe them in law because they may come and go or rename themselves from time to time. And that's the reason why we didn't specifically set it out.
88 O, Attorney General, you have an amendment.
Yes, ma'am. Thanks, Margaret. We propose, as circulated, Madam Chair, that we delete the word in 8801, that we delete the word 3 and substitute the word 2. And that in the table of the 7th schedule, sorry, that'll be clause 47. So in recognition of the submissions made by Senators Shriki and Ramkissoon, we sought to adjust the reset button down from 3 years to 2 years, so that even though you may get up to that point quickly, you can reset your clock within the 2-year period in recognition of the progress. I think it fits really neatly in with Senator Choate's amendment to Section 87A in the bill, which allows the court to review suspension on every occasion that you appear. So I think that there's harmony in the fulminations of the Senate.
Senator Shriki.
Thank you, Madam Chair. To this point, and it comes back to it comes back to the point with the merit register. Now that it's adjusted to 2 years, I'm asking for consideration as information on that side that the date at which the points can be expunged per driver, given a 2-year gap, is made known to them so that they would be aware.
It's definitely a feature of how we intend. We're trying to make this as user-friendly as possible because we're making it as stern as possible, which is why we are migrating to the electronic platform as quickly as possible. So we've spent a lot of time doing the data backfilling. Remember, data stopped being entered in 2010. We had 5 years of data to catch up on. We backfilled all of that for registration of vehicles, and we backfilled all for driver's permits, and we've now issued barcoding in respect of driver's permits. So we're trying to go into the electronic advancement, and obviously systemic resets or indicators to persons, because when we ask people in the Go Live to log on to the system, we're going to ask them to put an email address at which they can be contacted. So once the user interface starts to go, you're going to self-actuate. Your driver's license is about to expire, your points are high up on the record, listen, you're at risk of so-and-so, and it is going to cause a radical transformation of our country in a manner that people have been screaming for years. In the first Senate debate that we did in relation to the budget, I recall members vividly asking me for an undertaking that we would operationalize common sense and electronic transactions, and this is exactly what you have right now.
Chair, through you. You know, and very often when we make laws, we have to cater for the...
I can't hear you.
Whenever we make laws as a parliament, we have to consider the least... The protection of the rights of the least privileged citizen. And while I am in favor of electronic and paperless processing, we must also give consideration to the fact that there is a large portion of our population who do not have access to the internet and do not have access to technology. And I just want to say that when we have provisions like these, we sort of put more power into the corrupt element in licensing office to continue, because there is a regulation test to pass to get a driver's permit and people pay for it. We talk about that during the debate. And here, when you have the rehabilitation program, again, you bring a new opportunity for those corrupt elements to make money through fraud. And again, as we come down here, that is a concern I have, that we are not depriving that that portion of the population who do not have access. So my question is whether we could put a provision in place to send notification by mail. When we insure our vehicles, the insurance company would send us a letter about a month before the policy expires by mail, and something like that we could include here, so that your driver's permit, your notification, while you can't get it online if you interact, it should be a matter of procedure for that to be sent out via mail.
Sure. Madam Chair, what Senator Amin has raised is a laudable objective, if I could address it this way. First of all, the data penetration in this country is best evidenced by the number of cell phones in the country. The ratio is 4-to-1 right now in our country. So we have a significant internet penetration mobile market. Secondly, the user interface platform can also involve pulsed messages, depending upon the method of interaction, by text or message. Not there yet, but there's a potential for it. Thirdly, the notification is one which ideally is going to be building, but we prefer not to legislate it, and I'll explain why. If we put a positive obligation upon the licensing authority to issue warnings and notifications to people that their license is about to expire, that their points are going up, we are putting the burden of 1.3 million people and maybe 800,000 drivers or 700,000 drivers to rely upon the authority to think for them as to whether they should check their license, driver's license, to get their notification or not. So whilst we ease the obligation by giving better technology, we prefer not to take the burden onto the public, the state sector, for the issuance of those positions in terms of a prescriptive statement in the law.
No. AG, for example, you have a vehicle, you have a insurance registration. They send you a letter telling you that within a 1 month, and they tell you the date at which your policy will expire. If you do not get that notice in the mail, it doesn't mean that your insurance policy does not expire. And it's similar here. If you don't get the notification in the mail, it doesn't mean that you have a right to drive with that expired permit. It doesn't change the fact that your permit expires.
I accept that.
And this is why I'm asking for that provision to be put in, so that you do not only rely on the electronic interface between the user and on the platform that is provided, that is
I accept
being
that the
developed.
two may be mutually exclusive. The risk of including it into the parent law by way of a prescriptive positive obligation that the licensing authority take a step and notify such persons is a burden in terms of cost and administration. And I come back to the point that the efficiency is inversely proportionate to its size. And at this point in time, we just can't afford to do that. We may work our way towards that, but we're taking this thing in a very dedicated, measured approach for now. So it's in a best case world, it makes sense. Because it will be accessible online apart from emails. Yeah.
88Q, Madam. 88Q? Yes. Thank you, Madam President. Madam President, Honorable Attorney General, we are told that the demerit point register would be electronic. There would be very full and complete information on the infractions of every driver in Trinidad and Tobago, so that if I were to make a request, I would know exactly how many demerit points are registered in my name. But yet in 88Q, we have a situation where, in the last few words, if any person who has been refused a permit applies for or obtains a permit without disclosing such refusal, he is liable to a fine of $10,000 and imprisonment for 1 year. Now, I'm wondering if an individual in Trinidad and Tobago with our demerit point register so well functioning applies for a driver's license for which he was disqualified, should not at the point of application, the computer terminal should say, Mr. DX, you have been denied, and they just giggle amongst themselves and say, look at that fella, he's trying a fast one, instead of $10,000 and imprisonment. I am of the view that the mischief here is not if an individual were to apply on his name for a driver's license, but if he fraudulently applies, he applies under a different name, because if the computer system cannot pick up Mr. DX, How can it be sure, how can it guarantee me, the citizen, that all the demerit points are accurately recorded? Because suspension of a driving permit is the most serious, or as you would say, egregious of offenses, which ought to be picked up as soon as someone applies for it. So I am putting for your consideration that what you are really referring for EQ, 88Q, is not really an individual applying, but really fraudulently
I got you,
applying.
Senator, I got you.
Yeah.
May I, through you, Madam Chair? Number one, I think there's merit in what you're saying, not as it relates to the first part of the clause, but in the language that you've pointed out. Secondly, just to tell you where it came from, the current law in relation to perjury or breach of an oath, etc., is $10,000 and 7 years. Sorry, $50,000 and 7 years. So we went down to $10,000 and imprisonment for 1 year. If you'd bear with me, Madam Chair, if Senator Amin would bear with me, clause 88Q, if any person who, under the provision of this part, is disqualified for holding or obtaining a driving permit, applies for or obtains a permit while he is so disqualified, or if any person while he is so disqualified drives a motor vehicle, or if the disqualification is limited to the driving of a motor vehicle of a particular class or description, a motor vehicle of that class or description on a road, or if any person who has been refused a permit applies for or obtains a permit without disclosing such refusal. I'm wondering if we can say with knowingly and willfully refusing as it relates to that aspect. The language, I'm so grateful to see Senator Choate walk back in now, because I'd love to get her attention on this point.
Basically, what I want to emphasize, in the public interest, Honorable, can I continue?
No? Sorry, Madam Chair.
Yeah.
Senator Mahavi.
Yeah, thank you very much. In the public interest, I know the mischief that you want to address. I agree with everything in the first 8 or 9 lines. But it's just that when we already know that we have a very accurate register on demerit points, we also must have a very accurate register of individuals who have been disqualified. And so that an individual who applies on his own name is going to automatically be picked up by the system. No issue arises there, but really fraudulently. Would you consider if any person who has been refused a permit fraudulently applies?
Okay. First of all, I'll just remind, through you, Madam Chair, this clause is to delete a part and replace a part.
Right.
One of the casualties in the deletion, the repeal of this particular subset, is that we threw out Section 87, which we just improved with Senator Choate's assistance. Yeah. The other bit that we wanted to keep is actually Clause 88, Section 88 of the existing law. Section 88Q is word perfect in mirroring the existing law, which is Section 88.
Okay.
So the submission now is whether we should improve the language of the existing law as it relates to capturing fraud where you've been refused. Now remember, the mischief in this clause is, one, you're not supposed to be driving when you're suspended. It's a serious matter. Two, you're not supposed to apply for or obtain when you've been disqualified. But you're also not supposed to apply and obtain when you've been refused. Now, it may sound as if refused and disqualified are separated by some degree of severity, but a refusal is as equally severe as a disqualification, because you've been told up front, look, you just can't. Whereas a disqualification, there was a process by which you were told you no longer can. So the caution in my mind in introducing a qualification to the animus, the mental intention to commit the offense, the qualification in my mind to that is, do I want to disturb the existing law? And I've not thought about it in a deep sense prior to your intervention now. I see that Senator Choate has returned to the Senate, and Senator Sobers is here as well. Senator Coppin is here, Senator Rambarat, all equally attorneys at law on the deck. I welcome the views of the Senate as to whether there ought to be a qualification of the mental intention associated with refusal. for this particular offense.
Last point, AG, it's in relation to equity. And you see, there are two issues here. Someone has been disqualified, and he is caught by the police or the traffic warden driving a vehicle, and that is a severe offense. That's an offense, I think, worthy of your 10,000 and 1 year. But an individual, for whatever reason, he finds himself now at licensing office. That's the only place he can get a driver's license. It's an administrative area. He may have forgotten, I don't know, dementia or something, or he tries something. He's a trickster. But in the scheme of things, he's not causing harm to anybody. He's not driving without a license. Simply for applying, where in my mind, it's a crime that is punishable, but certainly in my mind, not by 10,000, especially since licensing office will pick it up immediately. And the mischief really has to be only when someone tries to obtain this vital document using some measure of dishonesty or fraud.
Taking up the point that Senator Amin has raised several times before, which is that there is fraud in the system. It may very well be that there's culpability with the licensing authority and the system may not pick it up, but we're seeking to place the onus squarely upon the person who ought to know, I've been refused and I've been disqualified. It's a serious matter of breaching the law. It's the existing law. I can tell you that in the subsequent renovation of the law, we, the government, are considering heavy criminal action for fraud by licensing officers, police officers, immigration personnel, customs personnel. Severe penalties for them, because that end of the situation has not been dealt with appropriately. But we're in consultation on those matters right now. So my question is really, do we seek to amend the mental intention as it relates to refusal, or do we leave the law as it is? I'm minded, because I haven't gotten the data behind this, to leave it as it is. It is word for word, save for the improvement of the fine, because the existing 88 says liable on fine of $2,000 or imprisonment for 6 months. So we have gone up to 10 or 1 year. We haven't gone as far as perjury or breach of oath, which is $50,000 and 7 years. We haven't gone that far. So I'm open to Senator's views.
Again, a final point. You see, I'm looking at the implementation. Driving without a license, traffic warden or police will lay a charge on you forthwith. Applying for the license and you have been disqualified, there is a clerk. Does the clerk have the authority to call the police, call her boss, whoever it is? They say this person has fraudulently applied. I picked it up in my system, and we will therefore file a charge immediately. I am not sure how it will work there, and it is for this reason I'm trying to prevail upon you that it is when the clerk detects fraud that is a punishable offense, and therefore
or the auditor when you're data entering, etc.
Right.
It may be cured by the qualification that you knowingly and willfully did something. Right. That's what I'm suggesting as a solution, potentially for consideration. Right. I've drawn the caveat that I don't have the data behind this to inform me sufficiently as to whether I should disturb the text of the existing law.
If I may, oh sorry. If I may,
I just want to add to.
Just a second. Senator Ramkisoon had caught my eye sometime before. So Senator Ramkisoon, then Senator Amin. Okay?
Thank you, Madam Chair. If I may just step off from Senator Danisar's point. If you look at Clause 94, which is a little ahead, but it says the same thing, like giving false information, which is...
Sorry, Clause 94?
Yes.
There's no Clause 94.
Section 94.
Section 94.
Section 94, giving false information. Clause 94 of the Parent Act, which is also amended because we're taking out the imprisonment of 6 months. But this says that if you give false information to the authorities, knowing that it is false, you will be fined $2,000. And this is the same thing we are trying to capture here, which is another fraudulent activity. I think it's basically the same thing, Madam President, but we have, for some reason, separated it, and it should remain consistent with $2,000, if so be it.
Yes, ma'am. Senator Ramkisoon, thank you for drawing the correlation to Section 94 of the existing law and this particular 88Q. It cautions me that perhaps if I don't have the data, I should leave the law as is and in fact return to $2,000 or imprisonment for 6 months because I've not yet treated with Section 94 in the overhaul. So
No
I think that your
problem.
eyes have spotted a very important point.
I totally endorse that point, AG. I think you could
So
maintain it.
Madam Chair, with your permission, subject to other observations.
Good. Thank you. Chair, the issue seems to be not where a person manages to get a permit without disclosing the refusal, but where a person makes the application. And an application, to me, involves two parts. Me, or the member of the public, filling out the form and taking it to the licensing authority, and them accepting it. And I am wondering if to solve the problem really, if a person tenders a form, completes an application form and submits it, that does that really complete the application? The application has to be accepted and the application could be refused, and I would think that the licensing authority, the clerk, would be authorized to refuse an application. And I think that's the direction we have to go. If the records show that this person does not qualify or is disqualified from applying for a permit, then the authority refuses the application. And so I want to add my voice of concern to that portion that says if any person who has been refused a permit applies for, just that section. However, I have no issue with the second part that says that if they obtain a permit without disclosing such refusal, which kind of alludes to some kind of fraud, but if they get it without disclosing, then I agree they should be liable to a fine. But I just want to take out that part from if any person who has been refused a permit applies for, just that part. Perhaps if we could extract it or change the terminology.
Senator Shriki-Soon.
Thank you, Madam Chair. Just one point, Honorable AG. This 88Q seems to have two offenses. One is driving after having been disqualified, and the other is with trying to obtain after. I'm asking, given that driving having been disqualified is a very serious offense, and the other is with respect to information and the activity of an individual, can we split this and have a clause specifically for being caught not driving, having been disqualified, and then deal with the reapplication?
Makes great sense. If I could address both submissions, first Senator Amin and Senator Shriki-Soon. Senator Amin's point about the application, I think can be, I'd ask her to think through, you, Madam Chair, or to contemplate on the fact that the application with an element of fraud, i.e., I know I've been disqualified, I know I've been refused. The mischief to be caught there is the fact that you're fraudulently attempting to obtain something. Whether you've obtained it or not is not the issue. It's the fraud in attempting that process. It sort of cleaves naturally into what Senator Shriki-Soon is saying, which is, should we not split the paragraph into, if you're caught driving, here's X, and if you apply, here's Y. Would you permit me a moment, Madam Chair, to speak to my team? Thank you. I'm told that, and we're trying to locate it now, that there is already a provision which deals with the standalone driving without a permit. So I'm just looking for that. So this one may be, there may be double positioning inside of here. It's section 40, is it? 42.1. 42.1. Yes. So 42.1 in Part 4 of the Parent Act deals with driving without a permit as an offense. And that's liable to $1,500 or imprisonment for 1 year. So it's caught there because if you're disqualified, you don't have a permit. If you've been refused, you don't have a permit. But now you're probably going to tell me, well, here's an egregious example of frowning on the law where you know you've been disqualified and you still went and drove without a permit. So there may be merit in cleaving it that way. So, Madam Chair, what I'm going to ask my technocratic team to do is to just think about how the clause may be separated in terms of a position on it. I'm sort of concerned that Melinda's friend, Senator Choate, has not yet volunteered a position on this, because I would welcome her submissions, if any, before we go off to do something.
Madam Chairman, if I may very quickly, I totally endorse Senator Shriki-Soon's suggestion. The difficulty we will find when we separate it is that the first part of it, what will be subsection 1, reads almost like a strict liability offense, and I think you want to put in something there to suggest mens rea. With respect to what will follow in subsection 2, if any person who has been refused a permit applies for or obtains a permit without disclosing, to me the words applies for or obtains cannot be understood without intention, because you can't apply without intending to apply. I can't think of a logical example where that might occur. Obtains might be a little different because it would be obtaining by fraudulent means. So I don't know how this could be addressed, because in this 188Q, we are moving in terms of the mens rea from almost strict liability to liability which you can understand, and then fraudulent liability. So I think perhaps that could be cleared up a little bit.
May we, with the Senate's permission, fulminate on a possible wording for a cleaving, putting in a mens rea which would match for the various circumstances, because quite frankly, the law is in its standing in Section 88 of the Act. The marginal note is fraudulent application for driving permit. So that's what the marginal note really intended to capture. It seems almost gratuitous that you're driving inside of there. That's a strict liability sort of position, which could be caught under 42.1, where you're driving without a permit. But you may want to aggravate in the new 88Q, as we're discussing now. So with your permission, Madam Chair, to ask the drafters to come up with a formula to capture where we are. And I'm wondering, insofar as we have other clauses, whether we could, unless there is a qualification to this and subject to your direction, proceed to confirm the views on clause 35, subject only to a revisitation on this?
No, I think that it will be cleaner if we do clause 35 in its entirety. So what we will do is stand down the
clause?
Proceeding on clause 35, and we will continue with the other clauses, and we'll come back to it. Okay? How much time do you need?
That implies that they will not be paying attention to the rest of the bill. So, Madam Chair, could I just ask at what point you propose to take the break?
In 7 minutes. So let us just continue with the rest of the bill for 7 minutes.
Sure.
There's a break, and then we will come back.
Much obliged, ma'am. Thank you very much.
So we have deferred section, clause 35, clause 36.
Clause 36.
So the question is that clause 36 stand part of the bill. Senator Ramki-Soon.
Madam Chair, through you, I would like for consideration to be looked at section 91C, where the offense is a fine of $3,000. I would like for consideration to be considered for $500 or maybe $1,000, because this is considering for drivers for hire where there's no provisions by public transportation.
Madam Chair, Section 91 is proposed to be amended via Clause 36. Section 91 of the Parent Act is the prescription for offences and general penalty as it relates to persons, firstly, who contravene the Act, secondly, who contravenes the regulations, thirdly, in subparagraph 3, where a driver of a motor vehicle who stands for hire at any road or place not appointed under this Act for the purpose or who contravenes any order made under this Act shall be guilty of an offence under this Act. Now, I paid attention to what Senator Ramkissoon had to say in the debate, which was the phenomenon of PH drivers, and in particular she gave us the reference to no cars where she lives and you have to go out, etc. But I just remind that standing for hire requires that you have a taxi H car and does not include the strict hidden elephant largely in the room of PH drivers, which so far has been unregulated in our jurisdiction. So from that purpose, I'm a little loath to amend the section because the law on PHing has to be improved, not put in the opposite direction. And so I respectfully ask the Honourable Senator, I can tell the Senate that the government is actually considering proposals on ride sharing, largely because they have found the missing element to regulation, and that is insurance. So there may very well be an opportunity to improve this position, but as my grandfather used to tell me all the time, many a slip between cup and lip, and there's a significant amount of consultation that has to go on with the industry holders that surround PHing and other aspects so that our society is equally treated. So I'd respectfully ask the Honourable Senator, through you, Madam Chair, to leave this clause as it stands.
Madam Chair, let me just say insurance is just as bad as bankers, just as bad, but in relation to the clause, the liable fine of $3,000, I find it a little stiff. I know certain senators disagree with me, but I'm telling you, because we have not amended the legislation for PH drivers, or we have not provided more public transport,
Senator
if we
Ramkissoon,
can
I'm sorry, but
think
that
of it.
question you posed and the Attorney General has answered. Okay?
If I could just
I'm just
perhaps
begging.
deal with the Senator's fears. Senator, the existing 91.3 reads as this: the driver of a motor vehicle who stands for hire at any road or place not appointed under the Act for the purpose of who contravenes any
Attorney
order.
General, I think you were very clear.
There's
in
one
your
other point, Madam
well,
Chair, I'd like to make. Thank you.
yes.
Shall be guilty of an offence under this Act. In decriminalising and in proposing only a fine, to be guilty of an offence, 3 would have jumped back to 91.1. So the existing law in 91.1 provides for $3,000. So they're not going up to an offence, it's just a restatement of the existing law when you apply 91.1 into the rubric of 91.3. So we're not moving at all from the existing law. And that's the point that I didn't get to make earlier, Madam Chair.
Clause 37. Just read it. Sorry? The question is that clause 36 now stand part of the bill. Those in favour say aye. Aye. Those against say no. Clause 36 now stands part of the bill.
Clause 37.
The question is that clause 37 stand part of the bill. The question is that clause 37 now stand part of the bill. Those in favour say aye. Aye. Any against? The ayes have it. Clause 37 now stand part of the bill.
Clause 38.
The question is that clause 38 stand part of the bill. The question is that clause 38 now stand part of the bill. Those in favor say aye. Any against? The ayes have it. Clause 38 now stands part of the bill.
Clause 39.
The question is that clause 39 stand part of the bill. The question is that clause 39 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 39 now stands part of the bill.
Clause 40.
The question is that clause 40 stand part of the bill. The question is that clause 40 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. The clause 40 now stands part of the bill.
Clause 41.
The question is that clause 41 stand part of the bill. Senator Ramkisoon.
Thank you, Madam Chair. In relation to this, Attorney General, I had, during my debate, asked if this could be amended to include barriers, road sign, roadworks, light poles, and traffic lights.
There's a separate treatment for traffic lights and signs now included in the measures elsewhere. The Honourable Senator's concern was that it was limited to road or bridge. We've not yet received information as to barriers, etc., and so I don't have the data to cause a policy shift away from the statement of law as it is. But we've dealt with the traffic lights, etc.
Is there a way to capture all of these?
Just remember that there are offences otherwise for malicious damage of property that don't need to be stated in this law. So it's not to say that there isn't law elsewhere as to causing malicious damage.
Well, this is particular for the state to recover the cost. So that's why I was looking at it. So for the state to get back the money when you do commit on the violation in this sense. So is it that can we say in any road, or is there a way to capture all of these property?
I respectfully don't have the data to cause a policy shift. So that's the problem that I'm wrestling with.
The question is that clause 41 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 41 now stands part of the bill.
Clause 42.
The question is that clause 42 stand part of the bill. The question is that clause 42 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 42 now stands part of the bill.
Clause 43.
The question is that clause 43 stand part of the bill.
Tidy up the legislation. Where
Attorney General,
Yes, ma'am. If
in
we
respect of clause 43,
yes, ma'am. And in fact, it will apply with 44 as well. The word "or" would change to "and." So hold on, let me make sure. No, Madam Chair, sorry. In 43, we're amending Section 107 of the Act by deleting the words "or to imprisonment." Similarly, in Clause 44, we're deleting it. So they stand as is.
so the question is that clause 43 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 43 now stands part of the bill.
Clause 44.
The question is that clause 44 stand part of the bill. The question is that clause 44 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 44 now stands part of the bill.
Clause 45.
The question is that clause 45 stand part of the bill. The question is that clause 45 now stand part of the bill. Those in favor say aye. Aye. Any against? The ayes have it. Clause 45 now stands part of the bill.
Clause 46.
The question is that clause 46 now stand a part of the bill. The question is that clause 46 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 46 now stands part of the bill.
Clause 47.
All right. So I'm seeing that there are some proposed amendments to clause 47. So I think this is a good time to suspend. And in my absolute generosity, we shall resume at 5:45. So we are suspended until 5:45.